not sick, but I was in close contact with someone that is. So I'm just trying to follow the rules and be careful. So I'm on the agenda today to give you an open meetings presentation. Hopefully it works out well. I try to go through and update this presentation with some of the changes. You know, the legislature likes to renumber things and make little tinkers here and there. So hopefully we're all up to date. You know, just to talk about the Constitution of the United States, it talks about the due process rights of individuals. So we're not allowed as a government entity to deprive anybody of life, liberty, or property without due process of law. Those things can be taken away by the government. Due process, here's a kind of a generic definition, but the main point is that it demands a basic fairness of procedure and appropriate under the circumstances, which makes sense. There are two different types of due process. There's substantive due process and procedural due process. And as is evident by the name, procedural due process deals with the process of process, if that makes any sense. The main point of due process, procedurally speaking, is you give an individual notice and an opportunity to be heard. So if we're going to be dealing with an individual's, for example, a subdivision application, we're not going to hold the meeting in secret, and we're not going to just hold the meeting without him knowing that we're holding a meeting on his issue. He's going to be given notice of that and have an opportunity to be heard regarding that. We're going to listen to what his comments are and let him advocate for what he's trying to do. So when a government entity acts in that manner to affect somebody's life, liberty, or property, then you have to give them notice and an opportunity to be heard. And that's why we have the Open and Public Meetings Act. That's one of the reasons why anyway. The basic public policy of the Open and Public Meetings Act is that we're the government, and so we exist and to conduct the business of the people. Therefore, all the actions and deliberations of the body should be conducted openly so that everyone can know what's happening. And the chairperson of the public body is required to make sure that the public body gets these trainings annually, and that's why we're doing it. All right, so law is an interesting area. Things and words and phrases that mean what we think they mean in the common use don't always mean the same thing when you're talking specifically about a law. So we have to look at what the law defines certain words and phrases to mean in order to know what it is the law is actually requiring us to do. So one of the definitions is public body, an administrative or executive advisory body. Also includes a legislative body that's created by the Constitution, statute, rule, resolution, or ordinance, consists of two or more people, expends, disperses, or is supported by taxes, and is vested with authority to make decisions regarding the public's business. And so that's you. You're county commissioners. You're both an administrative and an executive body, and you're also a legislative body. You're created by the law. There's more than two of you, obviously. You expend, disperse, and you are supported by taxes, and you're vested with the authority to handle the public's business. And so you meet the definitions of a public body for purposes of the law. Next, what does meeting mean? Well, it means when you guys get together with the quorum present, even if you're only a quorum by the use of electronic communications, and you're discussing or receiving comments from the public about stuff that you have the authority to make decisions about. So obviously a county commission meeting is a meeting for purposes of the Open Meetings Act. So quorum means what we would all think it means, a simple majority of the members of the body. But it does not include a meeting of just two of you, two elected officials by yourselves, when you don't take any action, either formally or informally. And that's important because, I mean, you guys are going to be talking together from time to time, sometimes just casually or socially, other times maybe about county business. But if you're not taking any action, either formally or informally, then it's not considered a quorum, and it wouldn't be a meeting for purposes of the Open Meetings Act. Does that make sense? Mm-hmm. All right. Let me know if you guys have questions. I can't see you. I can't see how you're reacting to what I'm saying. So if you're bored to death, I don't know. And if I'm talking gibberish, I won't know.
Everybody's still awake, Mike, so we're good.
All right.
We're wrapped
All
with
right.
attention.
All right. A meeting does not include chance or social meetings. And this applies to you guys convening of a public body with both legislative and executive responsibilities. So that's you guys. You have both executive powers and legislative powers. And if when you guys meet, you're not expending funds, and if you're convened solely for the discussion or implementation of administration or operational matters, and you're not taking any formal action, and you're talking about something that wouldn't normally come before you for formal action, then it's not a meeting. All right, so there's some procedural requirements for the notice. We give both an annual notice. That's just of the date, time, and place. And so John takes care of that. He lets people know that the commission's going to meet on these Mondays in Parowan in the county commission chambers at 9 o'clock. He takes care of that. But there's also the 24-hour notice requirement, which includes the same stuff, but also the agenda. And that has to be provided 24 hours before your meeting. That's posted in writing at the office or meeting place and on the state archives website. Hopefully that makes sense. A matter that's brought up by the public may be discussed even if it's not on the agenda, but you can't take any action on that item. That was changed, I think, a few years back. It used to be that if it was not on the agenda, the issue, then you can't talk about it really at all. So you are allowed, but you're not able to do anything about what they bring up, not on the agenda. You can have an emergency meeting, and we've talked about this before, for unforeseen circumstances which necessitate a meeting to consider matters of an emergency or urgent nature. You got to give the best notice practicable of that emergency meeting. And that would include the time and the place of the meeting and notice to be considered. But if the circumstances don't allow you to provide 24 hours notice, then that's okay. You can still go forward, but it needs to be, you can't abuse it. You can't say, we're going to pretend that something's an emergency that really isn't, just so that we can have a meeting without providing notice. That would be a problem. Now, you can't have a closed meeting for a number of purposes. One is to discuss the character, the competence, or health of an individual. That might be an employee or discussing an issue that an employee's having, and that might be of a private nature. And so you can go into a closed session for that purpose. If we're going to engage in collective bargaining, which the county does not, you could meet in a closed meeting to discuss the strategy for that, or discuss pending or reasonably imminent litigation, which we've done before. Also, if you were to acquire, sell real estate, we could meet in private in a closed meeting to discuss that. If you were going to have security personnel or devices in the county buildings, you can meet in private to discuss that. So that, otherwise it might contradict or invalidate the security efforts you're trying to take if it was all public, what exactly we were doing. And so things for safety like that, you can meet in public to discuss that. Sometimes the tax commission might act in the capacity of a board of equalization discussing commercial information for commercial property tax purposes. Sometimes there's protected private information that is discussed during that time, and so you can meet in a closed meeting for that. Certain types of procurement discussions. It's kind of similar to when the county wants to acquire real property or sell real property. It hurts the county if the strategy behind the decisions that you make is public. Well, the same thing can apply when you're trying to purchase some things. No, not always, but some of your procurement discussions can be held in a closed meeting. All right, so all your meetings have to be audio recorded, all your public meetings anyway. Complete and unedited of the open portions of your meetings, and it needs to be labeled so that the public can find it, and it's available to the public within 3 days. We have to record the closed meetings as well. The purpose of that is if you were to discuss something in the closed meeting that was not appropriate to discuss in a closed meeting, a judge could go back and listen and make that determination. And if that was the case, then the recording of your closed meeting would be available and open to the public. So John takes care of our minutes for us. Your minutes have to include these things that we would assume that it would need to include: the date, time, and place, the members of the county commission that are present, what you talk about, the individual votes that you take or make. When members of the public are present, we need to have their names down and their comments, and any other information that's part of the meeting that you guys want to be part of the minutes is in the minutes. So it's important when a member of the public speaks that we get their name, and so that can be included in the minutes. That's a statutory requirement that their name is placed in there. Also their comments. That's sometimes hard to do because sometimes people feel very welcome to just interrupt someone or ask questions from the gallery in there, from their seats. That's a problem because it doesn't really make it to the recording, and it might be difficult for John to hear their name or what they're saying. Also, sometimes people are talking over each other because you guys are sometimes discussing matters that people are pretty interested in and have a lot of passion about, but we need to make sure that the meeting is held in order so that we can get everybody's names and comments. At least that's just one of the reasons why it needs to be orderly. So obviously the meetings of the open meetings are public records and they're open for the public to use. Even pending minutes that haven't been approved yet are available to the public. They should just be marked or otherwise stamped that they're not approved yet. If you guys do or go to a site visit, you would also have to have minutes of those as well. I've done that before with the Planning Commission. We went to a site to see whether or not the Planning Commission felt like it was an appropriate place for the use that was being requested for a conditional use permit. Well, there needed to be minutes taken of that meeting that was held in a van and on site. And so it's kind of an interesting situation, but those minutes are required for those situations as well. Minutes are optional for closed meeting. If minutes are taken for the closed meeting, they're considered a protected record, meaning they're not open for the public to view it. Again, unless a judge goes back and determines that the things that were discussed as part of that closed meeting were not appropriate for the closed meeting, and then they would be available to the public. There's some exceptions to the Open Meetings Act. There's some case law exceptions, specifically if you were to deliberate on a decision you were to make in a quasi-judicial capacity, that would be that could be a closed meeting. So that could happen, for example, in an employment situation. Say there was an office or department that terminated an employee and they went through the appeal process and it came to the county commissioners. When you three meet to deliberate on what decision you're going to make, you don't have to sit there and deliberate that in an open meeting. You guys can meet in a closed setting to deliberate amongst yourselves. And what they've compared that to in some of the cases is when a judge is thinking about a case, sometimes he might be at home, he might be taking a shower, who knows where he is, where he's thinking about a case. He doesn't need to be sitting on the bench in front of the public and vocalizing all the different thoughts he has on a case. Well, you three together make that decision, not just one of you individually. And so you guys can talk about it in private as well and come to your decisions. If you're conducting administrative business that doesn't require any formal action, then you can also have an exception to the open meetings law. If it's an issue that you don't have any jurisdiction over, then it's not an open meeting. So I think this was an issue with some of our commissioners. I believe it may have been Kane County. They went to meet with some Washington, D.C. officials regarding some public lands, lands that were held by the federal government. And they were trying to get the federal government officials to make a certain decision. Well, the county commissioners in whatever county this was, I don't know exactly. I kind of think it was Kane. They didn't have any authority or jurisdiction to make this determination on the issue themselves. It was actually the federal government that did. And so when that was kind of an issue, people were arguing about it. To me, it was a pretty simple answer, and I may be wrong, but that was a matter over which that county didn't have any authority or jurisdiction. And so when they met together to discuss or maybe lobby those federal officials, that was an exception to the Open Meetings Act. Do you guys have any questions about that, or does that make sense?
Mm-hmm.
Okay. This is really weird giving a presentation to an empty room. It's kind of, at least it's from where I'm sitting. I don't know if you guys are even listening or not, but anyway.
Listening.
So a violation of the Open Meetings Act is enforced judicially. There'd be a case brought by the Attorney General, the County Attorney's Office, or any affected citizen. The judicial case would be brought for the purpose of compelling compliance, preventing a violation, or declaratory judgment, and attorney's fees can be awarded. There is a statute of limitations for 30 days if it considers a matter that the county is going in debt for, 90 days for all other matters. Again, I referenced this earlier. If there's an alleged violation about what occurred in a closed meeting, the judge reviews the recording to determine whether or not it was a violation. And if there is a violation, any action that you took on that issue is voidable. But you can cure a violation by conducting a later meeting on the same subject that does comply with the act. So you meet again, you have the same discussion, you talk about the same issues, and then you take your vote in that capacity, and that can cure a violation. An intentional or knowing violation of the act is a Class B misdemeanor. All right, so Commissioner Cousins told me one time that he went to a training where they talked about an Open Meetings Act, and it was really fast, and he thought that was super awesome. And he was kind of daring me, I think. I don't think he said it explicitly, to see if I could be faster than
I think it was 3 minutes, Mike.
And I'm sure I'm way over that already. But as I looked at the agenda, it pretty much gave me until 10 o'clock. So I'm going to take the time and give you something else to chew on. I like to talk about this as well when we talk about the Open Meetings Act. Well, I got you, because this applies to you three as well.
Mike, before you go on, I did have one question going back a little bit. So you
Okay.
mentioned that site visits. If we have a quorum going to a site visit, we need to take minutes. Is that correct?
Yeah, so if you're going to go together to look at something that you're going to make a decision about, so again, the example I gave you was the Planning Commission went to view a site that was applying for a conditional use permit.
Mm-hmm.
And there was some question about whether or not the infrastructure was appropriate and if it was the right spot, or if it was going to cause other negative impacts to surrounding properties and whatnot. So in order to make that determination, the Planning Commission wanted to go look at it. And when they did, that's an open meeting, and there needs to be minutes taken of that.
So I guess my question is,
notice.
last week, Commissioner Wood and Mike was going to go, but Commissioner Blake was going to go, but he was sick. But we drove up to Cache County and toured their jail as committee members to look at a future jail construction. So do we need to submit minutes of that trip?
I don't think so, because you're not deciding anything about the Cache County Jail, are you?
No, we're just getting input and ideas.
You're just going up to look at it. So every time you're together and you go look at something, unless it's county specific, unless it's county business, I don't think it's a problem.
Okay.
There's a fine line there somewhere. If you were to go, let's see, I'm trying to think of an example. I gave you the example in a land use. It's going to usually be in a land use setting.
Okay.
But yeah, if you were just to go tour something, I don't think that would be an issue that's not in the county, that you're not making a decision about that. Then I think you're fine.
So what if we went to look at a land use issue, more than two of us, or two or more? Would we have to actually notice that as well?
So yeah, that's what we did in the Planning Commission. I sometimes take credit for something I had nothing to do with. I think it would have been the building department, maybe through John. They published notice that the planning commission was meeting at this day and this time to travel to this location to look at this property. And that's what they did.
Okay.
So again, if you're going to meet together to discuss that or review that, and that's something that's coming before you and you're going to make a formal decision on it, then yeah, I think that you do.
Okay. Very good.
All right.
Thank you.
Yeah, no problem. Any other questions on open meetings before I move on over?
Do you have any, Marilyn? Mike, you have
That was
any?
good.
Okay. So I'll just say, the attorney always gives advice when you guys ask a question. It depends, and that's a very common attorney response because certain facts and circumstances could sway the answer from one thing to another. So if you have a question about a specific open meetings issue, just give us a call, and we'll help you through it. So talking about due process again in the decisions that you make, that's the due process clause again. So substantive due process is the focus on the decision itself, not the process whereby you make the decision. And the full scope of the liberty guaranteed by the due process clause cannot be found in or limited by the precise terms of the specific guarantees elsewhere provided in the Constitution. It's a rational continuum which, broadly speaking, includes a freedom from all substantial arbitrary impositions and purposeless restraints. That's a mouthful. For some people, that phrase would hurt their tender hearts, and other people, this is a great position to take on what due process means. Pretty much what it means is you can't just look at the Constitution to decide what is constitutional and what is not. You can't just look at the specific terms and specific guarantees. That's an arguable point to make, but it's actually a point that's been upheld by the court. There's a number of rights that the Supreme Court has found that do not exist explicitly in the Constitution itself. And the way they get that is they say, well, it might not be in there specifically, but if we look at the Constitution as a rational continuum, it's in there. Again, that can be scary or awesome depending on your individual perspectives. Again, substantive due process is the focus on the decision that you make, not just the process. So you can't make a decision that deprives a person of life, liberty, or property that is unreasonable, arbitrary, or capricious. And that would mean there's no rational basis or legitimate purpose in the decision that you made. A legitimate purpose would be something that has to do with the public health, safety, or welfare. Now, the courts will give a lot of deference to your decision under certain circumstances and not very much deference to you in other circumstances. So what does unreasonable, arbitrary, and capricious mean? It just depends upon the type of action that you're taking. So that's the depends word again, that it depends on what attorneys want to say. If you're making a legislative determination, you're given a lot of discretion. If you're making an administrative or quasi-judicial decision, you're not given nearly as much discretion. So examples of legislative decisions are amending ordinances. Anytime you're zoning a property, that's a legislative decision. Those are, you're given a lot of discretion in the decision that you make. Administrative decisions like conditional use permits, subdivisions, when you interpret an ordinance, when there's a variance, an appeal, those are all different types of decisions, and you're not given nearly as much discretion in the decision that you make. So if it's a legislative decision, the standard that the court looks at is it reasonably debatable that the action that you took could promote the general welfare? If so, then your decision will be supported. And again, that's a lot of discretion. But if you're making an administrative or quasi-judicial determination, you have to have substantial evidence on the record to support the decision that you make. And that's a much less discretion. Let's see. All right, and I just want to talk about this. This is just a brief thing about conflicts of interest. You need to disclose conflicts between your public duties and your personal interests of a financial nature. You're also prohibited from using confidential information that you acquire as part of your position to secure special privileges or exemptions for yourself or for others. And you're also obviously prohibited from taking, soliciting, accepting a gift or loan for yourself or another if that would influence your official duties. A $50 non-pecuniary gift is okay, especially if it's, if you were to get an award that was publicly presented, that's okay. A normal loan is okay. You can receive campaign contributions, and you can encourage something that supports the community. All right, this is kind of just normal, obvious stuff. Do you want me to go through all this, John, or Paul?
You can. We do have time, but
All right. If you want me to keep going, I will. So if you were to receive compensation for assisting a person in a transaction involves the county, you must disclose that in an open meeting. I don't know that that's ever happened that I can recall in my time with the county, but you would need to. Let's see if there's anything else. You have to disclose any business that you own that's subject.
that's something that our office takes care of each year.
Regulations of the county. You do that when you're first appointed, or it's a sworn statement that's filed. What's that? I didn't hear that.
Oh, I'm sorry. Those disclosures are taken care of by my office each year for the elected and department heads.
All right, and so this is the same type of situation. You make those disclosures so that it's clear what your interests might be when you make a decision. So you would disclose it in an open meeting to members of the body, and you disclose any personal interest or investment which creates a potential or actual conflict between your interest and your public duties. You're prohibited, the county's prohibited from having a situation in which a public officer directly supervises an appointee who is a relative when their salary is paid from public funds, which is pretty much all the county funds. So we don't have someone supervising someone that they're related to. Whoops. I think I missed a part. I don't know what's happening here. All right. We already talked about that. So there is a number of statutory provisions that deal with conflicts of interest and includes any situation in which their faithful performance of their duties or judgment could be compromised by their economic interests. And there's the County Officers and Employees Disclosure Act that discusses that and regulates that. So anyway, this is just normal stuff that you would know. It's pretty much common sense. Even if it applies to your family members, if there is an economic interest that would allow you to make a decision one way or the other, or would influence you, then you need to disclose that and probably recuse yourself. Sometimes you can just make the disclosure and still make the determination. I found that most people, when they find that they have a conflict of interest, they're not just going to just say it. They're going to actually recuse themselves. And that's probably the best decision to make. But that's not always the law that you have to follow. That's all I have prepared for you guys today. I know it was just open meetings, but I thought I would take the time to go over a few things as well. Any other questions for me?
Any questions?
Nope. Good.
Commissioner Blake, do you have any questions?
Nope, I'm good.
Okay, very good.
Right.
That was great. Great training. Thank you,
Probably put you guys on mute for a while, if that's okay, and see if I have any of my court cases being called. If you need me for anything, would you just give me a text, and when I'm done with court, I'll just hop back on and listen, okay?
Yes, we will.
Thanks.
Thanks.
Thank you.
Let's see. I think that's it for this meeting. We'll go ahead and take a break until 10 o'clock and resume our county commission meeting then. Thank you.
I could get in and out back here. But it didn't seem to work.
Oh, what happened?
I had to go get blood work.
Oh, yeah, you're on their schedule on that kind of stuff.
But all minutes were done, John. Between the minutes were approved.
All right. Yeah, they're all done. The 9th, the 23rd, and the 14th.
Somebody really worked hard on those, didn't they?
Yeah, nobody did it, and it was you. Hey, what's your phone? I got a call, see if your phone's inside.
It's only Bridget calls me. I told her about that and she just started laughing. I said, they all just love that one.
You would normally explain to read what happened.
Yes, and I was trying to get it to come back up.
Oh, that's right, yeah.
Yeah. But I have to have that one for her, that's because she has most of my grandchildren, so that's what I put hers on.
I don't blame you.
And her kids are always giggling and laughing and so.
Don't blame you.
And my mom has that on her phone when I call, because I give her the most grandchildren.
It's hilarious.
I know, it was.
We thought we were laughing at him.
I know, and I tried to put it down. I had it like really low, I didn't think it would go, you know.
It was loud enough for me to hear.
Just for the two of you, yeah, right there. At least I got you guys to.
That's right. That's right. Loosen up a little bit.
Yeah, I know.
Oh,
We got a jacket here.
okay. Yeah. No, it was part of that. I was late. Trying to take care of my cards and other stuff.
I didn't grab my, I got my shirt, but you want my door, right?
How's it going?
Good. Good, I haven't had to do anything yet.
Okay.
Well, President Nelson hasn't called me for any input. No, did he call you? He told me he was going to, but that was then he hung up.
He would have to have called you to tell you that he was gonna
Well,
call you.
I didn't have a chance to give him any input. He hung up.
We looking up like still that I'm okay with that. Oh, yeah.
John, can you get me on here? I put in my drive, and I've got some slides to show.
Yeah, yep. Let me check there. We've got a short right in the cabinet here somewhere. That's why. Am I seeing?
Don't blame it on the cabinet maker.
That's our cabinet.
You know, I think that probably was the case. wasn't
It probably was. You know who made it?
Probably a grabber screw through all the wires.
It probably is. Shorting out.
It's actually within the thing, and it's actually you touching this. But
So we're saying it does not work?
well, the internet can see what you're doing. The room can't.
Dan knows where to bang. He can come up here and hit it when it goes
And
out.
The touch,
What do I, oh yeah, I know exactly where to,
because we're all shorted out here.
just gotta,
Just need a
Yeah.
bigger hammer. Just need a
yeah,
bigger hammer.
you gotta belly up,
Easy there, killer.
you
I
gotta
know.
pretend you're Norm and cheers.
Norm.
You gotta go like this. That's usually what does it. Maybe it's done, Gene.
Oh.
You flashed.
We ought to pull that panel off and see what's loose. There must be a plug that's just not plugged
I'm
in
sure
tight.
it's just halfway out. It's probably been falling out for a while.
So those aren't working then? It was working. What happened?
There we go. I was flashing.
The irony is, it is on the internet, but it's just not on our screens. Yeah.
Well, anything that's intermittent usually gets worse, not better.
Yeah.
It's like, oh, it's fixed. Oh, there it went again.
Yep, almost.
It must just be barely hanging in there.
Yep, I'll bet that's
We
exactly
gotta pull
what.
that panel and just see.
You
if
gotta
it-
hit
Or
harder.
it's just a dumb plug.
Doggone it.
Give me just 2 shakes here.
And you need it to show. Oh, there it went. Does he need to have his monitor? I guess his monitor is a passive receiving device.
Yep.
It doesn't complicate any
Oh.
process.
I'm gonna pull that panel.
Yeah, that's great. Yeah, we're playing musical walls over here. Musical chairs, musical walls. Oh,
It's probably vibrated itself right out of it. Any connection that's coming and going is
probably
just
just
barely,
hanging.
barely touching it. Those things usually don't go in.
You get a cordless drill. I'm gonna do it right now, but later.
John does in the office, I think. Well,
Well, it's really kind of essential for this discussion to have the map.
somebody go see if there's one
We're adopting a
downstairs.
map.
There might be one downstairs.
Yeah, if you've got one.
Cordless drill.
So,
I know David used to have one, but I'll go see if John has one.
On my truck, on my truck. It's gotta be in there.
That works, right?
I was not sick. Let's. Why not? Well, I wiggle.
Yeah, do it on that side. That would make sense. It's gotta be a plug that's just
Can you
hanging.
wiggle the wires as they go into the wall? Oh,
That's what I'm doing.
it's not here at the computer.
We had this company come out.
Dan no longer has the touch.
Lost it, minus touch.
Dan, what good is Dan now?
Oh, oh, I found a sweet spot there, didn't I? Or Paul did.
I unplugged something.
Good video.
We should be recording this.
I know.
This is the kind of thing that farmers do.
That's right.
Ooh, get a hammer, bigger hammer.
This is the way the country
I don't know
judicial
if this
system
is working.
works.
I don't know how this is gonna.
Or I can take care of this. What I was thinking is, on the agenda,
That's right.
I wonder if you guys could just work on this for a minute.
Anything wire in there?
In the meantime, I'll pull this panel and see if we can.
Well, take long.
You're not gonna apply a new chair?
What? Yeah, we need to.
They've dropped in.
Of course, that only takes 30 seconds.
Install the mirror back.
I need a figure scraper as well, because we're gonna have to pull these plates.
10 times more effective than a
Oh, sure enough.
harness the power of the sun and poke that down in a hole, and you can see like.
I wonder if we can,
Have you got a regular
You wanna
scraper?
go direct to one of the screens?
I'll get one.
You don't have a permit, no?
Jared couldn't find one.
John, do we have a drill downstairs? Look at this.
Couldn't find,
Oh, here, yeah, we do want that.
couldn't find a
Do
cable.
we have an electric drill downstairs?
Yeah, that's what I thought. The problem is it's all behind a panel.
Well, and it's running by this device.
It is.
Go hard from one of those monitors, and that's not a PDF, that's not an HDMI. That's it, but there's a converter right there that goes to HDMI, I believe, right? That's probably HDMI plus HDMI.
Well,
Yeah. So, and I have a long HDMI cord in my office.
we've got one in that other room. And actually, Reed, maybe what we could do,
When I unplugged this HDMI, I think did it do something?
Nothing recently.
because what we could do, Reed, is use that laptop, or even I've got another one downstairs that we could just grab and hardwire it to that one TV.
Yeah, that'd be fine.
All right.
Yeah, it's just, it was only in the tier maps, so we're adopting those maps, so you really need to be able to see that.
Yeah, and I can't, and where it's shorted out, I could even,
Well, I didn't bring the laptop over.
well, I've got
Got it
one.
on my phone. Some of them.
Okay.
Pictures of them.
That's long enough. Maybe we don't get a laptop.
This may do it, though. I think it'll do it.
Hey, John?
This goes into,
John went down to get a computer, Paul.
Let's try this and see.
Dan, I probably
Well,
shouldn't
something
unplug
happened-
anything until he
something
shuts it down
happened
right, correct?
I think it was the fact that, I don't know,
Was when you
if Paul
unplugged
did
that.
it or if I'm.
let me, okay, let me put this one back here to see if we ruined.
Did you take it off?
Back on.
Here, plug that back into.
Well, now, see, that mouse went on there.
Oh, you know what it is?
Oh,
What is
what
it?
did I just do? I just.
John doesn't have anything on that screen right now.
Uh-oh. Here you've been paying
That
it
could
on
help.
everything. Oh.
Open up something.
There it is.
He didn't have anything on the screen. I think we bumped it and got it on, but it was black.
It's an
And so-
IO error.
Your Paul is
Something
under
loose in
the
there, right?
desk.
And I
Well,
need 10
if it's working, if it's working now, we'll pull that panel later and try to find what's loose.
We know we need to.
You never know what's gonna happen, right?
Let's off, let's just leave that, 'cause he went to get his laptop and then he needed it for
I don't know if he ever.
You didn't have a good screen.
Hey, John,
They said you didn't have it.
It wasn't up.
we had a black screen was on, so even when we were kicking it and getting it on, it was coming on with black, and there was nothing to see. We noticed it when we moved it
Oh,
over the mouse.
you know what? That was my fault.
I moved it being halfway on in between.
That's
the
an
screens.
ID10T error.
That's what we just said.
So can you get me?
We,
I don't know what you guys are saying, but.
we made a motion while you were gone. You took me a minute.
We made a motion to bring up something besides black.
Yes.
So you've got to
I'm
move,
so sorry.
you've got to move that all the way over onto your black screen.
Be on there, though.
How about that?
There you go.
Push the right button and stuff happens.
Okay. But it's still got a short, doesn't it?
Yeah, oh yeah, we need to address it.
We'll pull that panel after the meeting if we have time. And
I'm so sorry, that was my
See
bad.
if there's something there.
all right, here we go. Tell me when we're good, John.
Yeah, go ahead.
All right. We will go to meeting this Monday, the 11th day of January, 2021. It's about 10:12 a.m. And we will go to agenda item number 1 for the reorganization of Commission assignments and appointment of the commission chair for 2021. Just a note, we were going to meet last week with Commissioner Blake and Commissioner Wood and I to discuss the assignment sheets, but because Commissioner Blake has been down, we'll probably forego that until a further meeting. But as far as the assignments, we'll just leave them as is. Commissioner Wood will assume the assignments from Commissioner Adams, and we'll just leave those the same. And they may stay that way. If they don't, we'll make a change and bring it up at a further meeting. So with that, I'll entertain a motion to appoint Commissioner Blake as the commission chair for 2021.
I'll second that.
Well, go ahead and make the motion.
Oh, do you want me to?
Yeah.
Okay. Okay, I'll move to have Mike Blake, Commissioner Blake, as the commission chairman for 2021, and myself to take over Alma's assignments until we're able to meet again for 2021.
Oh,
Oh,
Okay,
that's kind of
and that was seconded by Commissioner Blake. I did hear that faintly.
did you,
maybe we
mess
undid
with
something.
anything?
Whoops.
I mess with everything.
Because it's coming through that onboard speaker.
I just unplugged this and plugged it back in, but everything else is the same. I just unplugged that and put it back in when we were trying to get it.
Well, that's not a deal breaker.
I mean, I heard him, so.
Yeah, me too.
Sorry, we're having some technical difficulties. So it's been moved and seconded to appoint Commissioner Mike Blake as the commission chair for 2021. All in favor, say aye.
Aye.
Aye. Mike, did you vote for yourself?
Nope. Did we lose him?
Yeah.
Oh, shoot. You might get him just on the phone.
That's what I'm going to do is call
Yeah.
him.
Yeah.
Might be better.
Well, here, let's. No, you're fine.
We're having major problems this morning. Let me put you on speaker. Did you hear? Oh. Okay, I'm going to put you on speaker, Mike. So how did you vote for yourself?
I did vote for myself.
Okay, you're official.
With that being said, would you continue with those duties today for just a lot easier for you to run the meeting in person?
Yes.
Yes, I will. Yes, I will. Thanks, Mike.
Thank you.
You bet. Should we leave him on the phone?
Yeah, for a minute. So I would suggest maybe that you appoint a commissioner pro tem. So
Okay,
basically, Commissioner
okay.
Wood.
Because that's done. We need to then,
Yeah.
okay. So would you make a motion to appoint me as Commissioner Pro Tem to finish the meeting?
Yes,
Chair Pro
thank you.
Tem. Chair Pro Tem. Yes.
I'll make a motion.
Here Mike's going to do it. Mike's gonna
Didn't
do it.
never stop.
Okay, Mike's
Go
gonna
ahead,
do it.
Mike.
Okay. I would move for approval, naming Commissioner Cousins as Chair Pro Tem to finish out this meeting.
I'll second that.
Okay. It's been moved and seconded to make Commissioner Cousins Chair Pro Tem for the remainder of this meeting. All in favor?
Aye.
Aye. Motion carries. Thank you. Okay. Mike, is it okay if I just leave you on my phone, and when we need you, I'll hold you up to the mic?
Yeah, that'd be fine. I'm having trouble getting back in and making my GoToMeeting link work.
Okay. All right. We'll just leave you on live and then go from there. So we'll go to agenda item number 2. This is a public hearing to receive public comment for a proposed zoning ordinance amending code section 17.36.230, location of mobile homes, travel trailers, recreational vehicles, boats, camping trailers, truck campers, and motor homes. Amending section 17.17.030, table of uses, and section 17.20.010 definitions, and adding section 17.36.232 recreational vehicle temporary use 1 to 16 days, and 17.36.234 recreational vehicle seasonal use 17-180 days per year. And Reed, you want to go ahead and you want to discuss this, and we'll open it for a public hearing?
Morning, Commissioners.
Morning.
This is an ordinance that the Planning Commission has been working on for some time to provide a clearer and better process for which we can identify the location of travel trailers, RVs. We just throw them all into that category of RV. But this is just what I have up on the screen, and I have some copies if there are others who are interested in a copy. It summarizes, this simply summarizes what's happening for the benefit of the ordinance. This is essentially what the ordinance does, all summed into one page here. So it creates several different categories that we haven't really had in the past. The ordinance in the past simply prohibited, and I'll scroll down here to the bottom of this page. Well, I'll have to go to the other ordinance. It prohibited the placement of RVs on any property other than for storage in the backyard of a property that had a house on it. Or the placement in a travel trailer park. So it prohibited the placement of a travel trailer outside of a travel trailer park on any property previously. And we recognized that there were two things going on in the county that we really needed to address. One was that there was a desire for and a use occurring for RVs to be placed on mountain property, seasonal property on the mountain where they would pull the RV up for the summer and leave it there all summer. And that was technically against the ordinance. And the other thing was that they were being placed on residential lots and being lived in and for various periods of time. And so we wanted to clarify and try to help with enforcement on those ends. So in essence, what this ordinance does is it creates in category 1 the placement of 1 or 2 travel trailers or RVs in all residential and agricultural zones for up to 16 days without any permit or anything. It would be very similar to public land where they can go onto the forest or onto BLM and stay in camp for any period up to 16 days, after which it has to be removed from the property or removed from that site. So that's the simplest and the first category that this ordinance creates. And in the ordinance, it's called a temporary use, a recreational vehicle temporary use. The second category is what would be called in the ordinance the recreational vehicle seasonal use, which would allow for the placement of a mobile home or a travel trailer on a private property up to 6 months in seasonal areas that would allow for them to place them like a mountain cabin and be able to use them in areas that are accessed only seasonally. We have another ordinance in the code that is entitled seasonal subdivisions, and it has we use language from that ordinance to create this ordinance in terms of what qualifies for a seasonal property. that which is closed seasonally because of snow and weather conditions. The county closes the road, or it's just not accessible because of winter conditions. And that's where these would apply in this second category. The third category is the placement of RVs in what currently is allowed in an administrative as an administrative land use permit in an ordinance for 1 to 5 units, or excuse me, 1 to 4 units, that they could be placed in an RV park. Okay, and that's essentially what Category 4 is, where they're very similar, 3 and 4. 4 allows for the rental of the space, and 3 simply allows for the use of the space, okay, in the residential zoning districts. Okay, so in the residential zoning districts, you can have one there up to 180 days, but in the A20, RA20, and commercial zones, with just an administrative land use permit, you could have a travel trailer park where you could rent spaces. And then in Category 5, if you want to do a larger travel trailer park where you have 5 or more travel trailer spaces, then that requires a conditional use permit in the agricultural 20 and the commercial zone. Those are things that we've had in the ordinance previously. And that's why the Category 1, 2, and 3, and 6 are different, because really you could only put them in a 3, 4, or 5 previously. Now you can put them in the other categories. So the Category 6 is a new category that is essentially in the ordinance called a recreational vehicle space, which allows for in any of the residential zones to the placement of in A20, RA20, and R5, similar to Category 3. The 3 and 6 are similar, other than that 3 in the smaller residential zones, it allows it up to 180 days. In Category 6, it allows it to be there year-round for a travel trailer to be lived in. And so those are the categories. You can see there the X is that in those smaller residential zones, they're not residential or recreational properties, and so we don't allow for the placement of a RV to be there and lived in year-round, but it allows it to be put there with a space where there's a connection for it for guests and people to come and stay in and stuff like that. So those are the categories. That's what the Planning Commission has worked through and recommended to the County Commission for approval. We've had a lot of discussion about it. We had a lot of concern from some of the subdivisions. Cedar, Check-Shawnee Cliffs, for example, was one subdivision that they, in their CC&Rs, had a prohibition to have any RV on a space that was outside of on a lot outside of a shed. It had to be in an enclosed building. And when they heard that we were working on this and they were modifying their CC&Rs, they attended several of the Planning Commission meetings to try to see where this is going. And some of them thought 14 days or 16 days was too long. Some of them definitely didn't like the provision to have it up to 6 months if they had a space for it. But they will amend their CC&Rs according to what they felt was necessary. But we got a lot of good input from a lot of places throughout the county in terms of how these should be placed, and feel like that this represents the public interest in that it allows for a lot more use of private property and placement of RVs than what we had previously. Okay?
Okay, thank you.
Thank you.
So we'll go ahead and open a public hearing on this agenda item number 2 for those that would like to make a comment or a question. Please state your name for the record.
Yes, thank you. Good morning. My name is Volney Morin, and I would like to speak to the public interest of preserving liberty. I'm a little concerned about creating regulations and then charging people to do things on their own private property. If there's an issue regarding unsightly neighborhoods, I believe that could be addressed by either a homeowners association or a property owners association or some other private means besides enacting complicated regulations that people have to pay a fee for. Thank you.
Thank you.
Thank you.
Thank you, Bill.
Okay. Okay, thank you.
My name's William Pressgrove. I concur with what Maureen said. The papers that I gave you are from another section of your code in the county. Okay, that it comes under Title 8, which is health and safety. I disagree with this proposal. I disagree with the table of uses in general because of the fact that it puts people in jeopardy twice. If they can't get them under the table of uses for some violation, then they can go to the health and safety section and they can prosecute them under that section as well. That's double jeopardy. In essence, everything that is in the health, safety, and general welfare of the individuals of this county are contained under the health and safety section, and specifically Chapter 8, which talks about nuisances. Okay, anything that is a nuisance, 3 people can complain about, and then the county has to act on that, on those complaints. It gives everybody the responsibility for their own property, as well as gives them an opportunity to mitigate or take care of any problems that 3 of their neighbors, for example, are upset about. There's no need for the county to go in and have a whole nother section of table of uses that tells each individual, you cannot do this, you cannot do this, you cannot do this, which takes away their, number 1, responsibility for their community, and number 2, their right to do with their property as the Utah Constitution says, an unalienable right or an inalienable right to acquire, possess, and protect property. The statutes that we have put into place using the authorization of the state to do so, in the state regulation, it's Title 17, 27A or something of that nature. I can't remember exactly. But the word is may. It says the county may institute provisions of this nature. It does not say it's mandatory. The state doesn't say that you shall or you must. It says may. And when it says may, that gives you the option of whether you want to or don't want to put these things into effect. I believe that it also opens the door for things in the county to go overboard to where personal property and rights are being violated. One person's rights violated because another person says, or the county says, that the majority of the people don't like this. But that's still violating that person's rights to their property, to do with their property as they see fit. I'm sorry, Reed works really hard at his job, which falls under the auspices of doing these things or setting these things up for the county. I don't And he probably did a good job on trying to put this together. But the whole thing is below a mandate that violates individual rights. If people have problems with their neighbors, the first thing they should do is talk to their neighbors. Not the first thing they do is go to the county commission or the planning board and say, this guy's doing something I don't like. When the county gets involved in this depth to things that are going on in the county, it abdicates any responsibility that the person has for themselves or toward their neighbors, and it takes all that responsibility and puts it squarely on the commission. And that's not where it belongs. Individuals need to be responsible for their own actions, not have their actions taken away or labeled as a violation of a county code. So what I'm saying goes a little bit deeper than this, because it involves the fact that the entire code is supposed to be for the health, safety, and general welfare of all the citizens. But if you look through the table of uses and other parts of the ordinances, it takes away the individual's responsibility for their own health, for their own safety, and for the general welfare of all of the neighbors that they have. I admonish you to take a really strong, hard look at the way things are set up in the county code, in Muni Code, and decide what parts of that are in violation of individuals' rights. The nuisance ordinance right there specifically says if 3 people complain, then the county must act. Okay? So why should the county say, we're going to take that responsibility away from those 3 individuals, and we're going to do it ourselves by setting up a table of uses that restricts everything? In the very first part of Title 17, Part 17B says that nobody can do anything on their property without the permission of the county. That's what Mussolini did in Italy. He said, you can have your private property, but I'm going to tell you what you can and can't do with it. That is fascism. And we don't need a fascist county. Thank you.
Thank you.
It's Bill.
Any other comments?
Make a comment. I haven't read this ordinance or anything else. I know
State your name.
Justin Wayman.
Thanks.
But I will say this: if you're relying upon the nuisance ordinance, you're already behind the 8 ball. It's better to be proactive than reactive. It's difficult once people get down the road and then you go to the nuisance ordinance and you say, well, you can't do that anymore. It's already a mess because you're already there. Dealt with the nuisance ordinance a lot, and I haven't read this ordinance, so I'm not weighing in whether it's good or bad. But I am telling you this: if you're relying upon the nuisance ordinance, you're way behind. You're already behind the 8 ball. So the nuisance ordinance is the last resort. And again, I think it's better to be proactive than reactive. It helps significantly.
Okay.
That's all I have.
Thank you.
Thank you.
Any other comments? Input? Seeing none, we'll close this public hearing and open it up to the commission for any comments or discussion. Commissioner Blake, are you there?
Yes.
Do you have any input?
I've got a question in regards to how does this ordinance jive with talking about public health? How does this ordinance jive with our Southwest Public Health Department and the laws and ordinances that they're governed by?
Do you want to address that, Reed?
This is Reed Erickson. Hello, Commissioner Blake.
Hello.
I think the simple answer to that question is that It follows the guidelines and the requirements of Southwest Public Health. We consulted with them on the provisions that are put in specifically in this ordinance regarding the recreational vehicle seasonal use. There was some question of whether or not we should have require septic permits, and we talked about that a lot, and whether or not the Southwest Public Health would issue a septic permit, because the septic permits fall under the jurisdiction of Southwest Public Health. There was some question of whether they would issue a septic permit to a year-round residence if they were hauling water, and for the seasonal places. And Southwest Public Health rule is that they do not issue a septic permit and will not issue, so in terms of health, safety, and welfare, they've determined that if the facility cannot provide a year-round water source, they will not issue a septic permit for that. They will issue septic permits for a seasonal septic permit if you're hauling water for seasonal use only, but not for a year-round use. And so we talked about quite a bit about on these properties out west and where RVs have been parked and people are living in them and hauling water. And we had a visit with the director and both people for our region, for the health inspectors and his supervisor that's over it on the 5-county level, as well as the Dr. Blodgett. And they wanted to emphasize and hold firm that it's a health and safety concern if we start issuing permits and allow for year-round living if somebody doesn't have a good source of water for culinary year-round. And that we were kind of a little bit on pushing it from their perspective that we would issue a septic permit for a seasonal. But since we've been doing that, Jerry Jorgensen, who is the health inspector for Southwest Public Health, said that he does more of those in Iron County than anywhere else in Southwest Utah because of the mountain and the accessibility and the use and the fact that the county will do it. Some of the other counties don't do it. We do consider seasonal use to be able to allow water hauling for existing lots of record, not new subdivisions, but we actually do in a seasonal subdivision. Part of the provisions that we have in the new seasonal subdivision is it does allow for hauling water for seasonal use for new subdivisions. And we're one of the only areas that does that in this region. So they feel like they can support that, but couldn't go any further than that in terms of issuing water permits for places that don't, and septics for if they're not year-round, don't have a solid water source. Does that answer your question?
Yes, thank you.
Reed, while you're up there, so didn't this, when you were talking about the 180-day seasonal use for RVs, and there was talk about requiring a septic, like for instance, if you have a lot on the mountain,
right.
Didn't that get taken out?
Yeah, let me read the language. I'm reading from page 4 of the ordinance, which is 1736-234.
Okay.
And it says sewage requirements. The Southwest Utah
number? Oh, 3. Okay.
Number 3.
Okay.
The Southwest Utah Public Health Department and the Utah Department of Environmental Quality shall be considered the county's experts in evaluating the proposed sewage treatment system or containment option. It shall be the responsibility of the applicant to provide information and materials as required by Southwest Utah Public Health, the Department of Environmental Quality, as applicable, necessary to evaluate the proposed sewage treatment system. So before it said you have to have a septic. Now it's saying sewage treatment system or containment option. So they could have a holding tank, and if Southwest Health determines that that's large enough and it's designed adequately, that it's not going to be spilling out on the ground, and that it has adequate provisions for public health safety, that they would allow that, and therefore we would. So it doesn't require, if they've got a larger holding tank on their RV and they determine that that's sufficient, then that will work. So it doesn't require a septic.
take it
They
to a
could just
dump
have to
station.
take it and dump it. If they had a portable little unit that they used there and they put their sewage into that and then hauled it off, that's fine. Whatever Southwest Public Health would permit.
Okay.
Yep.
All right, thank you. Commissioner Wood, do you have any comments or questions? Or
I know that Reed has worked tirelessly on this, and we appreciate his work on that. We still want to meet, and the Planning Commission also, a lot. They've done a lot of work on this. We still are, hashing it through, and it's quite complicated. There's a lot of verbiage, and so I think we'd feel more comfortable to approve it at a later date, but we'll keep looking at it, and
Commissioner Blake, do you have any other questions or comments?
No.
Okay. Thank you. And that's and I'll echo Commissioner Wood's comments. I appreciate the Planning Commission and Reed's efforts. But I do have concerns, and that's one reason I've asked that we don't vote on this yet. One thing in this body, oftentimes the Planning Commission, and I've been to most of them, and they're a wonderful body. They do great job. But my concern with this, as I've been in this position, is the Planning Commission has several months to discuss something that's complicated, and oftentimes it's put on our agenda to talk about it and vote on it in 5 minutes. And so I think the public hearing has been very helpful, but I want to take more time personally to review this and address some of the concerns that have been brought up and get some more feedback and make a good decision when the time comes. So any other comments on this?
Just let me know how I can help, and as you're reviewing it and have questions specific or want to consider other language.
Mike, hang on one sec. Go ahead. Hang on. Go ahead, Reed.
No, I was just offering that as you review it and you have questions, or would you like to meet and go over it, please let me know, and other suggested language or anything that can clarify, I'd be glad to help.
Okay, thank you,
Thank
Reed.
you.
Go ahead, Mike.
No, I was just going to say I concur. I've been involved on these issues quite a bit over the last couple of years, and I think this is a good step in the right direction. But I'm with you. As lengthy and complicated as it is, I'd just like a little bit more input from some of the boots on the ground, and I'm comfortable postponing this decision for a minute until we can wrap our minds around it a little easier.
Perfect. Okay, thank you, Mike. All right.
Did you close the public hearing?
Yes.
Okay.
Yeah, I closed it. I think so, didn't I? Yeah. Okay. Okay. There's nothing else on agenda item 2. We'll go to agenda item number 3. This will be a public hearing, and we will vote on this item after we're done. To receive public comment on a proposed general plan tier change and zoning map amendment for property affected by the recent dissolution of Cedar Highlands Town.
So I actually reached out to Mike Edwards about this, and he felt like because of the specificity of the agenda item, if he felt if we were more generic that you probably would be able to vote on it, but he felt like it probably wasn't a good idea to vote on it just because of the verbiage, and I do apologize for that. I wish we'd have got that. So
we can have the public hearing and discuss it, but vote on it at the next meeting.
Yeah. I'm sorry about that.
No worries. Okay.
It's okay.
I thought if it was on the agenda, we could. Anyway, that's.
I texted Mike. Do you want me to reach out to him again?
What would your preference be, Reed? Is it a big deal? Is time of the essence on this, or?
Only from the perspective that I'm not aware of any pending applications. Do you have any applications in right now waiting on this?
No, not this time. We do not have any current permits waiting yet.
So 2 weeks would be okay.
So I think that
Maybe
it's not
do it by
probably going to
next
complicate
week.
matters.
Okay.
Yeah.
Let's just do that then.
I do
If
apologize
they
for
feel
that.
more comfortable with greater clarification, that's fine.
Okay. You want
Want me
to
to
go
do
ahead?
an introduction?
Yeah, let's go ahead and do an introduction, then we'll open the public hearing.
I'm going to just run through a few slides to give a little background for you and the public in terms of this discussion item that has come to us as a result of Cedar Highlands disincorporating. I'm going to just pull a map up here that shows the Cedar Highlands area, and with my cursor, I can follow around here, and you can see this larger dashed area right here is what was previously the Cedar Highlands town, okay, the incorporated town. And so the dashed line, with the exception of just right here, which is kind of along the right-hand canyon road, this was the Cedar Highlands town where the white dashed line was right here. And then this was the Tier 2 previously. So in most places it's the same boundary, but there was just a little bit of difference there. We amended our Tier 2 boundary to follow the Cedar Incorporated Highlands town boundary when it was incorporated, and left some of the area that was previously in Tier 2 in Tier 2. So that's what we'll look at now. And so as we go forward, recognizing that when the town disincorporates and this area no longer is the town, then it's not zoned anything in the county, and we need to consider the tier, because the tier 2 is a growth area for that municipality. Okay, that's the idea of the growth or the Tier 2 system, and the tiering system was put in the general plan in 1995 as a growth management strategy from the perspective that Tier 1 is the municipality, Tier 2 is the municipality's growth area, and the legislature required municipalities to identify their, what they called their annexation expansion areas, or their proposed annexation areas. And so we used, when that was put in place in 1995, we used the city's municipal expansion areas to determine the Tier 2. And the Tier 2 was put in place with the idea that that's where municipal type growth would occur in the unincorporated area. The type of density, the availability of services. And so outside of that, we have most of the county is Tier 4, which means it's a rural, unincorporated, undeveloped with low densities. And then we created a Tier 3 for future urbanizing areas. So at the time of 1995, we had Summit and Newcastle, which were communities of sort but weren't incorporated. They became a Tier 3. And since that time, we've developed under the ordinance 2 other Tier 3s. One just off of Bryan Head Town called Aspen Creek, and another one out at Three Peaks Golf Community. So they were master plan communities that had a system of development, and in our ordinances in 2005 we amended the general plan to be more specific on the tiering for Tier 3 and the development of the Tier 3 areas. So you're aware also that and we're grateful in this budget this year that you appropriated funding to do some evaluation on 2 of our Tier 3 areas for what the appropriate septic density should be. And I've contacted the Utah Geological Survey, and they're drawing up language to contract with us to do a groundwater study in those areas to determine for Summit and Newcastle what the appropriate septic densities should be in those areas based on the groundwater availability. So these tiering systems are based on the idea that we would focus our densities close to the municipalities or in the municipalities and encourage annexation and development in those tier areas. So as we consider a tier development here, we want to keep that in mind, understanding what its purpose is. And then also the fact that once it's disincorporated, or what they call the disillusionment of the town, it had no zoning. And so as people come to develop, we don't know what to tell them, what their setbacks are and what the appropriate density would be for any other development there. So that's what we're doing here, is trying to determine what the appropriate density would be for that Cedar Highlands area. As we look back at the history of this is a map from 2001 that shows the Cedar City annexation area, and you can see how much has changed over time. This kind of purple hatched area that goes beyond what it was most recently was much larger. Then in 2006, this is an example after our 2005 general plan amendment, and we looked at the way that the tiers were structured. You can see how much it shrank. I'll just go back to the one previously, and you can see the purple hatched area is much, much larger than what it is in 2007. And then in 2000, this is also the zoning map in 2007, where it shows the Cedar Highlands subdivision was zoned R1 half, or half acre, and the area to the east and kind of south around that was zoned R5. Then in 2010, I'll come back to that in just a second. Here's a map of Cedar City's expansion area. This is essentially their future land use plan that shows their future annexing area. And you can see that it doesn't go very far up the hill. Let me go back here. This purple is the same as what the green was. And it just identifies it as the general natural open space area and allows for densities possibly, if there's development in that area, 1 per 5 acres. On some of that development. This is that same annexation expansion area. As you can see, the map is titled Future Annexation Map. That's what they would consider for annexation, which does not include Cedar Highlands or the area around Cedar Highlands. So as we began to try to evaluate what that should look like in terms of density and what's already there, recognizing that the Cedar Highlands subdivision has been there since the 70s. And so in the late 90s and the mid 2000s, we were looking at some concerns there with a subdivision proposal and saying what kind of density can we have up above Cedar Highlands for a subdivision there. And it came to light that there were some concerns about the landslide. There was a number of studies done and a number of evaluations. We put a moratorium in place at that time on any new building for 6 months while we developed an ordinance. And as a result of that, we now have Chapter 1759. This is a geological conditions ordinance that identifies what needs to happen in order for somebody to get a building permit in there and what needs to happen in order for subdivision to occur there. At that time, we also zoned the property that was R1 half and R5 back to A20 and R5 in the Cedar Highlands subdivision itself. The zoning was R5 for the subdivision, but then in the motion it said we'll zone it R5, but we'll use the setbacks for R1 half because of the steepness of the lots and some of the things that were there. So it was a bit complicated in that most of it was zoned A20. Around it, everything was zoned A20, but the subdivision itself was R5 with R1 half setbacks. That was done in 2010. And that's the way it's been since then, until the town was incorporated in 2018. They created a zoning system in the town that allowed everything that was in the town to be R1, which was 1 acre lots, without a lot of forethought in terms of all of that BLM to the south and everything between Cedar City and them and on the mountain. And I think that they looked at it from the perspective that that's what most of Cedar Highlands was, and that they, through their process as they did development, they could regulate the zoning and the densities. But they never did develop an ordinance for subdivision or a zoning ordinance. They just, when they incorporated, said that will be R1, which was 1 acre lot. So there was some belief at that time that there was some entitlement to property that then came out of the town that they would also still continue to be allowed to be R1. Just last Thursday, I believe it was, the court, then the Judge Bell determined, and Mike could share a little more information on this, but denied any claim of any entitlement to any development that was in the town, that there's no provisions for or entitlement for him to continue with an expectation that he could have 1 acre density, okay, in that area. So what's happened since that time also is the Cedar or the Central Iron County Water Conservancy District has taken over the water system. There are 165 lots in the Cedar Highlands subdivision itself, and those are currently about half developed out. When we looked at the zoning and we looked at the tiering, we tried to evaluate what's the likelihood for development in that area. What is the potential for new subdivisions? How many are there? What's the impact on the groundwater? One of the things that we learned out of the landslide evaluation and discussion was really only there was all of the experts, and we brought people in from California, Southern California, and the landslide areas and all over. The only real thing that they could all agree on was that without doing a multi-million-dollar study where we went to a broad area and drilled a lot of holes and did a massive evaluation for the whole area to determine the viability of the landslide, the only thing they really all agreed on was that the best thing we can do is just try to minimize the number of septic systems we have on the mountain that would minimize the amount of groundwater going in that would enhance this landslide. The more groundwater you're putting in, the more likely it would be for there to be a slide. And so the less we put in, the better off we will be. And so that's the simplest answer and the real only thing that everyone agreed on in the end. That's what we could do. And so the ordinance that was developed was structured off of that idea and the evaluation of geologic conditions. So that's why we take into consideration total lots, the water system, where the springs are, where the wells are, kind of try to evaluate that whole situation. Recognizing that without the town now, Cedar Highlands has a homeowners association that had existed prior to the town, continued through the town, in fact, had a lawsuit with the town to determine jurisdiction of roads and maintenance. And so now they have the community, and they're kind of the community organization up there. And we have one member here from the board. Reggie is here and has attended the planning commissions and many meetings as we've discussed this, and has given great input, and we've appreciated their feedback on these considerations as we've gone forward. We've also had continuing, just kind of an aside a little bit to the zoning, but looking at the road issue going up the mountain, and we've met with the Cedar Highlands leadership for the homeowners association, and we'll continue that discussion in terms of alignment and maintenance and improvements and trying to do something there that will help the situation. So what the recommendation came from the Planning Commission then was, we said, first let's look at it from the perspective of, if the yellow line were the Cedar City annexation expansion area, if we made the Tier 2 boundary there and left all of the other stuff out and into Tier 4 and just zoned it all A20, then it would be kind of like it is before it was incorporated. It was other than the Cedar Highlands subdivision. Okay, this was what the staff recommended as a tiering system, just because we thought that Cedar Highlands, in order to have the kind of density that they had there, needed to be in a Tier 2, and so they had a potential there for the future, and that's the recommendation for the tiering. We also looked at zoning the Cedar Highlands subdivision itself, with the exception of the open space. You can see a division boundary right here with my cursor. There's a line here and here and here and here that is part of the subdivision itself, but it's in the subdivision, it's open space. And so our proposal was that we would zone the subdivision developed lots within the subdivision, the developable lots, R1, the areas outside of the subdivision lots, and the area around it, all A20. And we had considered a proposal to look at some R5 zoning, along the area that there was the concern of entitlement to R1 and the potential for some development there for 5-acre lots. But the Planning Commission determined that we would be better off giving the landowners an opportunity, move the tier boundary back to where it was previously to include 10 20-acre lots along the east side here, but zone it all A20. That way it's within the tier 2 that allows for higher density. And one of the things I may not have mentioned earlier on when I was talking about the tiering system is that tier 2 is where you have to be in order to develop down less than 20-acre lot sizes. So tier 4 and outside of tier 2, other than in tier 3s, the maximum density or the maximum density or the minimum lot size is 20 acres. And so to consider anything smaller than that, you have to be in a tier 2. And that's why they felt like we could consider that for this area along this side and put that into a tier 2. So the bottom line is that if you look at the heavy yellow boundary, that's the Planning Commission's recommendation for where the tier 2 should be. You can see all of the other yellow hatched, the yellow dotted lines is what we would essentially be taking off the map, which was what the tier 2 used to be. There's some up in this area and then a little bit here. So we would follow here, and this is where the tier 2 used to be, would include this lot. There's 10 lots here, and include this area to be zoned A20, but in tier 2, this area to be zoned R1. So everything around Cedar Highlands would be zoned A20, but this is where the tier 2 boundary would be. And that's what the Planning Commission came to after discussion in several meetings and input from Cedar Highlands and the developer there. Linford Nelson has a fair amount of property, owns all of these lots along the east side here and a bunch of this property here. And he was at the Planning Commission meeting. And so the Planning Commission determination was to recommend this configuration for the zoning and the tier 2.
Reed, one thing that helped me, maybe you could show the public where the road is, and if anybody that's driven up there will realize how steep those lots are.
So you can see the road coming in. This is the right-hand canyon road, and this is about where the sea is, right in this area right here. And so you can see where it splits off right here and goes down into the subdivision. This is the right-hand canyon road that continues up, and you can kind of see it winding up through here, and it's got a big switchback here, and goes up onto the mountain here. The Cedar Livestock Trail you can see going down here, okay, the Livestock Trail, and this is the road that goes up the face of the mountain right here.
Yeah, it's just those lots were added in the tier 2, the A20s. That is very steep.
They're up above the road. When you're driving up there and going up the canyon, it's everything up above you to the left there to the east, up where the towers are, clear up on top. Those are right on the top of that tier. So it is very steep. 20 acres, they're large lots. That makes sense for them, and that's the developmental potential right now.
Very good. Well, we've got Reed up here. Are there any questions from the commission for Reed?
No, not on this one.
I just have a comment. I know down below it's all BLM, right?
Correct.
And that's a watershed, so there probably won't be development there ever.
That's correct, and there are some
nice.
concerns that they have what they call a withdrawal area,
For a watershed
for
type
watershed
of thing.
protection. Yeah, and that was taken into consideration. And as we look at the road here and worked with BLM, that came to light. So we're not looking at any potential for development in any of this area because of what BLM has that categorized.
Yeah.
Okay, very good. Thank you, Reed. We'll go ahead and open the public hearing on this issue. If there's anybody that'd like to comment, you can come up, state your name, and seeing none, we'll close the public hearing. Thank you. And we'll go ahead and have John put this on the next agenda to vote on. Appreciate all the work. This was kind of a complicated one, but I appreciate all your efforts.
Commissioner,
Yes.
Justin Wayman is here to address an item, but it's a bit further down the agenda. I don't know if you'd be willing to
Let's do that.
Which
yeah.
one was it?
forward
that now.
to number 10.
What's it worth to you, Justin? Come on up. That'd be great. So we'll go to number 10 next. And this is a discussion and possible acceptance of a planned quiet title action regarding land within the Bullock Trailer Court on Center Street in Cedar City.
Okay. Whoop. Gave me two.
Oh, thanks.
Yep. Thank you.
So, this one might be helpful too. This is the Bullock Trailer Park right now. That's the walls.
Mm-hmm.
So that's the fences that go around the Bullock Trailer Park. They started to look at this. We realized we had all kinds of titling problems. Mr. Bullock, Henry Bullock, from a long time ago, started acquiring this land back in 1936. As he worked on this land, what had happened was owned by several different people, and then the county foreclosed on a huge parcel from a Robert Bullock, who's long since deceased. They foreclosed on it in the tax sale in 1936. Then Henry Bullock and other people started acquiring the property. As they acquired the property, because the inartful ability to describe, do legal descriptions back for the last 100 years, they messed up a lot of the legal descriptions, for lack of a better word. We were able to clean up everything with Keith Christensen and Donna Christensen on the left-hand side of that property. The blue line outlines the exact description right now of the Bullock property. But that doesn't reflect where the walls of the trailer park are. So what they did is the owners of the trailer park are just interested in quieting title to land within the trailer park boundaries. So they started looking. If you look at the green that's been kind of colored in with the green map, that's an approximate. That's actually owned by C. Ray Hunter. So she came into the lawsuit because she's been maintaining this property, which is deeded to the Henry Bullock Trust, where all the green coloring is. And she's been taking care of that for years. So we brought her in. And one of the other problems was her parents, Woodrow Jansen, owned a strip of land still through her property and into the Bullock property that never got deeded out either because of a titling there. So the Bullock said, look, we'll just deed to you the property that's over here. Oh, I didn't know you had that. That's great. So we just deed to you the property that's you've been taking care of because we don't want it. We just want the property within our fence boundaries. That little green highlight, which is the handout I gave you, is where the X is. That was never deeded out from the county for some reason. When the county had the big parcel, they had this huge parcel, and that piece just got missed. And so I talked to Mr. Edwards out at the early and kind of onset and said, I'm going to have to sue the county to try to just clean up this little piece of property here. And then after we did it, we got it all filed and everything. And before I had a chance to come talk to the commission, my staff sent it out and actually got you served. So I was going to talk to you before we served, but he got ahead of me. So what we're asking the county,
I always like to hear from you, but
yeah, not on those type of things, right? So what we're just asking the county to do is to stipulate that we can quiet title for that little green area right there, which is inside the fence boundaries and has been, and it's been used by the Henry Bullock for the last 100 years.
Is it kind of a steep
Well, I'll walk over here.
going down to the creek, or?
Yeah, so this land, C. Ray Bullock is taking care of all her life. And her husband's passed away, and she's elderly. But she has been taking care of this, and it's all decorated and landscaped. She always thought it was her property and never even realized it was the Henry Bullock property. They're actually related. Everyone's related to Bullock.
Right.
From Cedar City, somewhere back in there. But so the fence comes down here and then comes across right here. So this is steep, and frankly, we're not quieting title to this down here, even though it's in the Bullock name. We're just quieting title over to here and then down this one to the fence. wants that, we'll just deed it to the city, whatever portion they need for the creek. If they decide to put another trail on the other side of the creek or something, they can have it. It is steep from right here over, as it goes right to about here, it just drops off really steep. But we're not quite entitled to anything on the steep part, because that's our fence line. That blue reflects our fence line of what's been for many, many, many years. So we're just asking the permission from the county commission to give Mr. Edwards a permission to sign, stipulate to us quieting titles to that little green parcel of property.
Okay.
Commissioners, I spoke with our recorder's office. We don't even show this as being county property. It looks like there was just a mistake with the deed and the title. So this, from all county perspective, this isn't even county property, and I don't see a problem if you would like to authorize that to be disposed of, as Mr. Wayman is suggesting.
One of the other problems was, as I said, the Jansens owned it. One of the other problems is part of this property was deeded to Robert Bullock, B-U-L-L-O-C-K, instead of Bullock. And then he deeded it on down the line in his name, but technically, once you deed it into the Bullock, it stays in Bullock name, and a different deed doesn't transfer the property. So we're cleaning up that as well. It's just a mess, and it's been a mess for 100 years.
Okay. All right. Is there any questions or discussions from the commission?
I would like to say that this particular area has been a challenge in terms of just trying to map it. The section corners and things have always been a little weird, and so this having modern description modern survey will be fantastic. I think the work that Justin Wayman has done is excellent, and I think it's important to point out that title company actually discovered most of these title issues.
Yeah, Cedarland Title was one that we had 4 different deeds that were bad.
Okay. Sounds like a challenge. Well, I'll entertain a motion on this agenda item.
Do you want me to?
You're good.
Yeah, go ahead, Marilyn.
Okay. Move for acceptance of the planned quiet title action regarding land within the Bullock Trailer Court on Center Street in Cedar City.
I'll second.
Okay, it's been moved and seconded as described and is so eloquently described by Mr. Wayman. All in favor? Say
Aye.
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 Thank you
Motion
very
carries.
much.
Thank you, Justin. Always good to see you.
You moved ahead on the agenda. I'm behind Dan, Justin on a couple items. Number 11, I really like.
That's because you like to be here. We're not going to move you.
Justin's special.
You're usually at the front there, Reed. You're usually at the front.
Appreciate it.
Thanks, Justin.
Thanks.
Thanks for putting me at the end.
All right, so we'll go to agenda item number 4, 3-minute time limit per speaker for public comment. Participants should not repeat others' comments, only for items not on the agenda. No items related to commission's role as an appeal board. Comments should be directed to the commission, no attacks on other people's character. Any comments today? Seeing none, we'll move to agenda item number 5, the ratification of a contract to provide crushing of untreated aggregate base with quality crushing in the amount of $133,750. And I guess I can talk about this one. Is there anybody else that wants to? I signed this contract this last week. They were low bid. It was pretty much a no-brainer, and so we signed this, and this is just to ratify that. So I'll entertain a motion.
I would move for approval of ratification of contract to provide crushing of untreated aggregate base with quality crushing in the amount of $133,750.
I'll second it.
Okay, it's been moved and seconded to ratify the contract to provide crushing of untreated aggregate base with quality crushing, the amount of $103,750. And just to note, this is behind the county road building in the pit.
The name of the
Quality crushing. And so it's been moved and seconded. All in favor?
Aye.
Aye.
Aye. Motion carries. Thank you. Let's go to item number 6, approval of a lease agreement between Cedar City Corporation and Iron County for the Cedar City Senior Center. Mike, are you going to talk about this one? Or I can even talk about it if you want.
Can you hear me?
Yes.
I can talk briefly about it. This is the senior citizen center there in Cedar City. County has been in the process of doing an expansion on that building. And there's an agreement, a lease agreement that we need to authorize with Cedar City, given that the building is a county building, but it sits on city property, which isn't ideal. But this is the agreement to put that all into effect and in place. I would suggest that the county maybe look at purchasing the property so that we don't have a building that sits on another entity's property. We might want to pursue that, but in the short term, this is a lease that we can sign that kind of buttons it up so that our building is authorized to be where it is.
And I agree with that. Months ago, before we started this project, I went to Cedar City and visited with Tyler Romerl, the Cedar City attorney, and he seemed amenable to looking at just deeding that property over. But as it moved through the channels over there, they decided they would just continue with the lease. I reached out this morning and again said this doesn't make a lot of sense to me, that we should own the property our building sits on. We're putting over an $800,000 addition on that building. There's probably a $2 million structure now, and it just seems like we should own that property. So I agree with Mike that we should continue to, but for now we need to probably go ahead and sign the agreement for now. So, but we can work on that later. That's my
Should I
opinion.
make a motion?
Mm-hmm.
I'll move for approval of the lease agreement between Cedar City Corporation and Iron County for the Cedar City Senior Center.
Second.
Okay, it's been moved and seconded to approve the lease agreement between Cedar City and Iron County for the Cedar City Senior Center. All in favor?
Aye.
Aye. Motion carries. Thank you. Item number 8, discussion on possible adoption of the 2021 employee mileage reimbursement rates and per diem rates. Dan.
Did you want to do 7?
Oh, did I miss one? I'm sorry. Dan, do 7
7 and
first.
8.
You've got both those. I'm sorry, I skipped one. So 7 is the discussion of possible approval of additional credit limit for the Iron County credit card balance, and then we'll do number 8 after that. Thanks, John, for catching up.
Okay, so credit limit first. So the way we currently have our credit cards set up, just as a real quick little back story so everybody's in an understanding. The budgets are what the budgets are. The money's appropriated to the various department heads to spend within their line items. The credit cards are something that is a vehicle that is used to spend stuff. So regardless of what the credit limit amount is, they're only authorized to spend what they're authorized to spend on the things they're authorized to spend it on. Typically, we do a lot of things with by check at the county. The only other way really to do payment is by credit card, which which we do a lot of purchases via credit card. We've entertained the idea of switching to a P card, which is a purchasing card. There's a state contract, but currently we have the credit card we have is through State Bank of Southern Utah. We like our partners there. We've had various issues that have been resolved, some that are just fine. But as a entire county account, State Bank does limit us to a total credit card limit. And that's not expended funds, that's available limit. And so we have to then subdivide that available limit amongst the amount of cards that we have. So typically most of your department heads have cards, commissioners have cards, and then within the department, those that need to be able to purchase because they're mobile or they're out and about are issued a card, and we have to manage the available limits across all of those cards, and it can be quite a challenge. August in my office is the one that directly handles it as she pays the credit card statements and so forth. What happens quite often is because we have fairly small limits, there's certain times of the year when people will need a temporary adjustment. For example, if you have an officer, detective, or something like that, most of the patrol patrol officers have a card. But if they're going and they're going to a training or they're going on an extradition or something, they may need a temporary larger amount. And so quite often this happens where they call and say, hey, can I have a larger amount? The credit card bill hasn't been paid yet. Say they have a very finite amount. They have something on there, and then they're now going to try to reserve a hotel room with that card, and they're bumping into their account balance. Say their their limit is $1,000 or $500, and they're bumping into that limit. That does happen quite often. Every time we call down to the bank and get a temporary amount increase, they charge us $25, $15, $25. I can't remember what it is. This happens often. This is an expense that bugs me because it doesn't need to be. And so we reached out to State Bank. They came and visited in December to the treasurer's office, and they spent some time in my office as well to address concerns. And we talked about this. We said, how can we? Is there a way that we can give limit increases temporarily without incurring this administration fee, which they add up, and they did give us the ability to do that. What we need a buffer above and beyond the limits that are currently done. We need a buffer because we still can't go over our total cap. And so what I'm asking for today is a $10,000 buffer that won't be assigned to anybody in particular, but we can temporarily do this. And let's say the commissioners have a larger one, but let's say that $500 example, we can bump their limit up to say $1,500, which is for a time period, and then it automatically goes back to $5. They can do that transaction, we can get it paid, we can avoid that administration fee. This happens quite often. August would have the ability to do that.
So it's kind of a floating.
Yeah, it's a floating buffer that we're able to temporarily bump up into and really just avoid administration fees.
But you have to make them aware of that.
Well, we have to apply. And we can't apply without the minutes of approval from a commission meeting, from the legislative body. So they don't let us make any changes like of that nature to the account without minutes from a commission meeting. So that's why we bring it to you and ask. I mean, you can tell us no, and we'll just keep doing it the way we're doing it. But we're not really asking for more money, but we are asking for this buffer. So, anyways,
sounds logical to me. So I'll entertain a motion on that item.
I'll move for approval of additional credit card limit for the Iron County credit card balance as described by our auditor, Dan Jessen.
Second. Sorry.
It's been moved and seconded to approve the additional credit limit for the Iron County credit card balance as described. All in favor?
Aye.
Aye.
Aye. Thank you, Dan. Number 8.
Okay, so number 8, this is something we do annually. We have an employee mileage reimbursement rates that we review annually. And the current rate, mileage reimbursement rate, what we have historically done is we've tied it to the IRS standard mileage rate. In 2019, it was 58 cents a mile. In 2020, it dropped to 57.5 cents. It's rarely you'd ever see that go down. And in 2021, the rate has dropped yet again by a full cent and a half. So the new IRS mileage rate is 56 cents a mile. And I propose that we adopt that rate for the county. They do spend a lot of time and money and actuaries and economists and so forth to figure out what is a fair rate to reimburse an employee for the use of their vehicle, and that takes wear and tear and everything into account. And along with that, we have a secondary rate. That is, if a vehicle is available and an employee decides to drive their own vehicle, we we pay them a lower rate. If there is no vehicle available and they drive their own vehicle, they get the full 56. If there's a vehicle sitting out there, a vehicle that's available to their department, and they still drive their own vehicle, then we pay them a lower rate. That rate is 15 cents less than the normal rate. So what I propose is 56 cents per mile and 41 cents per mile if a vehicle is available and they so choose to drive their own. Also, we review the meal per diem rates for when an employee is traveling, and meal per diem is authorized. We base this on the Utah's per diem rates, and from 2020 to 2021, there has been no change. So what we are currently doing is $45 a day maximum, but that's subdivided into $11 for breakfast, $14 for lunch, $20 for dinner. And when the cases, if there are only one of those meals within the policy, then we would only pay which meal was available. If they're gone for the entire day, then the maximum would be $45 per day on a per diem basis. So mileage rate dropping by 1.5 cents per diem, remaining the same is our proposal, but you guys can do whatever you want.
Okay, entertain a motion.
I'll make a motion to adopt the 2021 employee mileage reimbursement rate and per diem as Dan has laid that out for us.
Would you just note the amounts in your motion?
Okay. 56 cents a mile on the regular car, and on your own car, if you choose to do that, 15 cents less, 41 cent. And the food per diem, 45 a day maximum.
Okay.
I'll second that.
Okay, so it's been moved and seconded as described. All in favor?
Aye.
Aye. Motion carries.
Thank
Thanks,
you.
Dan. We'll go to number 9. Discussion and possible approval of a contract for Indigent Capital Defense Council service on behalf of Joseph Edward Fott. Is that how you say that?
I think so.
Defendant.
So, commissioners, I think that you've seen one of these agreements for another defendant, part of the same case previously. This has to do with an individual that was found deceased near Enterprise, but on the Iron County side of the border. As you're aware, Iron County provides for the indigent defense of individuals. We have some contracts with some local councils to do that. However, this is potentially a capital case. And so in that circumstance, there's a state rule that says only certain individuals that are approved can handle those types of cases on an indigent defense basis. And so this is an agreement for you to approve. And the state provides these funds for these individuals to be represented. We just need you to sign this agreement if you're willing to. If you have any questions about it, I can speak more about it if you like.
Okay. Any questions from the commission?
No.
Okay. I'll entertain a motion.
I would move for approval of a contract for Indigent Capital Defense Council service on behalf of Joseph Edward Fott, who's the defendant in this case.
Oh, second?
Okay, it's been moved and seconded to approve the contract for the Indigent Capital Defense Council for the on behalf of Joseph Edward Fott. All in favor?
Aye.
Aye.
Aye. Motion carries. We've taken care of number 10. We'll go to item number 11, Resolution 2021-1. This is a resolution of the Iron County Commission of Iron County, Utah, adopting an ADA compliance checklist and grievance procedure, language access plan, reasonable accommodation policy, and effective communication policy. This resolution relates to an application for a community development block grant to improve the Newcastle Fire Station building. Go ahead, Reed.
You have copies of the policies that are outlined here. I would also make mention for ratification, John, you apparently pulled this off the agenda item but didn't put it as a separate item. The capital improvement list approval ratification. Remember?
Well,
that
now,
discussion?
wasn't that built into the resolution?
No. That's why it was listed separately as a separate item in the agenda request.
Well, I apologize. I thought that was built into the resolution.
Talked about you pulling it out, having it as a separate item, or just leaving it in the way it was worded. But you pulled the wording out, but then you didn't put it as a separate item. So I'm going to include it in this discussion nonetheless and ask for a separate action on it because it's part of what's needed for the grant. Okay, so let me handle that first. This is a grant application for the Community Development Block Grant for 2021. As part of that, each year we have to submit a capital improvement list, which are the things that we consider for funding during that funding cycles are due January 15th. So it happens to happen immediately. And I've already submitted the construction or the improvement list was due January 8th, last Friday. So I submitted a list with item prioritized H1 as the Newcastle Fire Station building with an estimated total cost of $600,000. The funding source or type of funding would be $200,000 from the Community Development Block Grant Program, $100,000 county match, and $200,000 for Community Impact Board application, which we have not yet submitted. But that's the funding proposal. We had looked at doing this project as a two-phase project. Commissioner Cousins brought this to me in November or so, and said, you know, can we get an application in on time to do this? And we have worked diligently to do that, and I appreciate Wayne Peterson, the fire chief out there in that area, for his recent effort in doing a income survey. We had to survey, based on the protocol for CDBG, 62 random homes out in their service area, and I appreciate Mary Lee's help in the clerk's office preparing the list for all of the residents out there who are currently getting a garbage facility. We use that list and the service area to determine the survey protocol, and have completed an income survey to show that this area qualifies for low to moderate income. And they're evaluating those survey results right now, but we expect that will show that we qualify for this grant. And so this agenda item includes two components. One, the ratification of the capital improvement list that was already submitted for this year to include that building with that cost estimate. And in the event that we don't receive the CDBG money, then we can continue to apply for the Community Impact Board funding to see how much we could get and then resubmit again next year as part of that match. Or we can look at different options on how that could be funded. But our best option, and what we had talked previously with Commissioner Cousins and with the Chief Peterson out there, is that if even only this year, if we couldn't get the additional CIB funding, we could put the shell up this year and get the enclosure completed with the CDBG money and the county's match to be able to get it enclosed, and then we would have to budget in subsequent years for the improvements inside and finishing off the building and the furnishings and things like that. But I think that the contractor that Commissioner Cousins had worked with to get an estimate, I think, was confident that we could do that for $300,000 and get the shell up if we can't get the CIB funding. But the CDBG folks at the state felt that CIB won't pay as a separate project for finishing off the inside of a building, but they would pay as a participant in the whole building. So if we submit for the project as a $600,000 project, with them only having to fund $300,000 and we're funding the other $300 with CDBG and the county, there was a more likelihood that we could qualify.
So we're applying to both
We will be
entities?
applying for the CDBG for $200,000 and CIB for $300,000
right now.
Well,
Or whenever.
CDBG applications are due next Friday on the 15th.
Okay.
So I'm trying to get all this stuff ready for that. We can apply for CIB later, anytime. And we probably won't submit the application until we know whether we get the CDBG funding or not.
Okay.
But it will be within the time frame that we could still build once we know what CDBG funding is.
So
So,
We need to
so
do
that's
some
the one
motions.
part of it.
Okay.
Okay, is the CDB or the capital improvement list that we have to approve, and maybe you want to take action on that first, if that's okay, and then I'll talk about the
So
resolution.
we first need a motion on the
Just to-
capital improvement
To
list.
ratify the capital improvement list for the Newcastle Fire Station building at $600,000.
Okay. You want to do that, Meryl?
Okay. I hope I can get that one where I don't have it all written down. I'll move on the ratification of the capital improvement list of the Newcastle Fire Department building, $600,000
For
Is that-
2021.
for 2021.
Perfect.
That work?
I'll second that.
Okay, it's been moved and seconded as described. All in favor?
Aye.
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 Motion carries.
The second item, the resolution 2021-1, is a resolution that adopts policies, the following policies as outlined in section 1 of the resolution. Section 504, an ADA reasonable accommodation policy, a language access plan, Section 504 and ADA effective communication policy, and grievance procedure under the American with Disabilities Act. These are all policy requirements in order that our county has these policies in place in order to qualify for CDBG funding. CDBG is a community development block grant. It's a federal fund that's assigned to each state. They give so much block of money, I think it's $11 million this year in 2021. And then the state distributes that based on the County Association of Governments districts, and they each get so much depending on what the applications are. There's no strict formula on how much each one gets, but we with the approval of these, we already have some policies in place for ADA. We will also be doing what they call a barriers survey, that removal of ADA barriers survey of all of our facilities. These things, the adoption of this resolution and that survey gives us one more point each of those two things in our application. And so since it's a competitive application, we wanted to make sure that we got all of the points possible. So that's why we're doing these.
Okay. And just a note too, when I talked to Chief Peterson, you know, the shell, if we can just get the shell up, that'd be great. He's having to store 2 of his trucks across the street in Bob Holt's potato barn, and he has to drain them every time. It's not conducive to have your fire trucks drained, and so we really need
They
to.
respond to a fire, they have to go fill the tank
Yeah,
first before they can
It's
go.
not
and
very
that's a
efficient,
lengthy
right?
process.
Yes, so we need to get a
Good.
place where they can park those out of the cold and freezing temperatures. So
The other benefit is that Newcastle really doesn't have any kind of community gathering place. And this facility with their training room, the facility is essentially broken up into 2 parts. One side is the bay.
2 bays, right? There's 2 bays.
Yeah, the open bay with 2 doors.
Right.
And the other side would be a meeting room and kitchen and gathering area and training room in the lower half, and the upper half would be for storage. But then it would give the community a facility. The
that's
church
nice.
there, the LDS Church, is the only
Indoor.
facility that any public can gather out there in the valley. And
Rural,
so
but it's quite a ways
Rural
away.
Community Center is a little further away, but for Newcastle itself, this would provide and be an important part of the community there in Newcastle. So I think it's also worth mentioning that would serve for that as well.
That's really nice.
Good. Well, I'll entertain a motion on that discussion. Are you ready to do that, Mike? Are you good?
Will one of you guys do it? I lost my screen again. I'm trying to get back to it.
Okay.
Oh, just number 11.
Yeah, just
Motion on that.
yes. Go ahead. Why don't you just go ahead and
Oh,
do that
should I
for us
just
now?
do it?
Mhm.
Okay. I'll move to approve the Resolution 2021-1, a resolution of the Iron County Commission of Iron County, Utah, adapting ADA compliant checklist and grievance procedure, language access plan, reasonable accommodation policy, and effective communication policy. This resolution relates to an application for the Community Development Block Grant to improve the Newcastle Fire Station building.
Second.
Okay, it's been moved and seconded as described. All in favor?
Aye.
Aye. Motion carries. Thank you very much. We'll move to agenda item number 12, personnel.
Thank you.
Thank you, Marie. Appreciate your help on that.
Sorry we didn't let you go sooner, Reed.
I'm sorry.
You can take that out on John.
Thank you. Good morning.
Hi, Jennifer.
Morning.
All right. First on the agenda is in the attorney's office. Holly Berman was selected from the most recent competitive recruiting and interview process to backfill an upcoming retirement position as a full-time legal assistant, effective date 2/8/2021. And if you want to go department by department, that's fine by me.
Okay, let's go ahead and make it. I'll entertain a motion on that item.
I will move for approval of a new hire, Holly Berman, as a full-time legal assistant, backfill on an upcoming retirement position, effective February 8th, 2021.
Second.
Okay, it's been moved and seconded as described. All in favor?
Aye.
Aye.
Aye. Motion carries. We'll go to B, Sheriff.
All right. In the patrol section of the Sheriff's Office, for your approval is the status change for Dustin Roy, who is moving from a full-time Deputy 1 status to a part-time bailiff deputy, effective date 1/10/2021. And then Nicole Willis was inadvertently placed on the calendar again. This time we covered it in detail last commission meeting, so that can be stricken from the calendar.
Okay, so that's scratch that.
Yes.
Scratch number
That one.
2.
Yes.
Okay. Okay. All right, I'll entertain a motion on that one.
Yeah, I would move for approval of position change for Dustin Roy from a full-time Deputy 1 to a part-time bailiff, effective January 10th, 2021.
Second.
Okay, it's been moved and seconded as described. All in favor?
Aye.
Aye.
Aye. Motion carries. We'll go to C, Assessor.
All right. Marlene Guerrero and Amanda Bagley were selected from the most recent competitive recruiting and interview process to fill the vacant DMV technician positions. Marlene is a backfill from a vacant position effective date 1/4/2021 and is also tested and has been approved to receive additional bilingual pay. Amanda is approved. Is a new approved position with the effective date of January 11th, 2021. Both of those positions are part-time status.
Okay.
Okay.
I'll entertain a motion.
I'll make a motion for the assessor's office to approve a new hire, Marlene Guerrero, as a part-time DMV technician, backfill position, vacant position, effective January 4th, 2021, and approval of a new hire, Amanda Bagley, as a part-time DMV technician, newly approved position, effective January 11th, 2021.
Second.
Okay, it's been moved and seconded as described for items 1 and 2 under the assessor item. All in favor?
Aye.
Aye.
Aye. Motion carries. We'll go to number 3, the presentation and discussion of assessor chief deputy status.
All right. This one I'll have Karsten represent his proposal for your consideration. If you have any questions for me, I'll kind of take a step back and let him run this.
Okay. Thank you, Jennifer.
You bet. Thank you.
Yeah.
Morning, Karsten.
Hey, morning.
Hi.
Almost
Karsten.
afternoon. 15 minutes. It'll be afternoon.
Yeah, a little bit. Karsten Reed. So, been on the job a short period of time, but I've had a chance to meet with a couple of other assessors in the state of Utah, and through phone conversations and just in-person visits. There's a little bit of a challenge with our county in terms of the just personnel and efficiencies, and that is a lot of it's relating to the size of our county and the role that an assessor has. So most counties, there are, an appraiser wears one or two hats. In our county, the assessors are, they're clerical, residential, statistical, data analysis. They're data collectors. So they have all these roles that they have to fill, and that is an inefficient model. So it's a really challenging way, an inefficient way to get things done. And we've been operating that way for a long period of time. So in my discussions with other counties in ways to increase efficiency, the way that they do it is they don't really, there might be a chief deputy, but there's division managers that are over a specific area of the assessor's office, which allows for, instead of an appraiser trying to do everything and juggle a million different things, it allows them to really focus on the tasks that they're hired to do. What it's done in other counties is it's allowed them to not have to hire additional full-time personnel. And we're probably at a point in our growth cycle where we've added a significant number of new units where we either need to add a new assessor or we need to make some kind of a change so that we can accommodate the workload that these assessors are under and the growth that we've incurred. So my proposal really is to create more efficiency by making a pretty significant change to our organizational structure, and that is to add a role of kind of a division manager, so that we can sort of divide these very specialized responsibilities and be more efficient in our operations. So my proposal really is to do that by adding a data collector and by adding a division manager or an additional deputy assessor for over residential or land, and so
assessor over what?
Over residential. One over residential, one over commercial residential land, and then have the specific responsibilities. So it's kind of a hybrid model, because obviously for example, the Washington County Assessor's Office, I think, is 5 times larger than our office. So they have obviously a much bigger organizational structure. I'm just trying to make it so that we don't really need to hire 1 or 2 more full-time employees, and limit that by maybe making a few changes organizationally to do that.
So, Karsten, are you proposing to add a data collector or just title someone in the office as a data?
So to actually add a data collector,
add one. Okay.
Yeah, a part-time person that their full responsibility is.
Can you explain the benefits of that?
So, in the private industry, maybe it's best to sort of discuss. In the private industry, the assessor is the person who's out in the field, and then it's an inefficient. If an appraiser, a real estate appraiser, is out in the field and comes back and has to write the report, it's just a very slow process. It's not an efficient model. So, what in the private world is done is an appraiser hires a report writer to write the reports, and then they're out in the field collecting all the data. And that way they can work through 2 and 3 appraisals a day rather than maybe get one out. So so it's a hyper efficient model to increase productivity. It's sort of the opposite in this line of work because you know, the data collection's done by the assessor, so they're out in the field. When they're out in the field, they're not obviously working on their mass valuation and all the things that need to get done. And in this office, there's a number of hats, so it's not just the one or two things that they're doing. It becomes sort of much less efficient. So the idea would be to conserve that particular and one. I mean, they have a whole office full of them in St. George. There's a whole team of data collectors. My thought is just to start with one and try to increase productivity so that we don't get pushed to the point where we're adding, you know, one or two full-time appraisers or assessors rather, which the office is kind of indicating where we might be needing to go. So my thought is if we can alleviate that by adding a data collector, changing the organization a little bit, that will actually cause an efficiency to not have to
just kind of see how it works. Is this what
well, see, it's already an efficient model. I think that works. That's sort of proven in other counties, but really so we're not, you know, growing by 3 positions when we're not quite ready, but almost ready. So.
And could you talk about this? Could you talk about the second half of your proposal?
Which
The
is
chief deputy part?
So it's in pretty much my proposal is kind of a hybrid of what is done in larger counties where they're trying to increase efficiency by moving away from, you know, well, not all of them have gone away from a chief deputy, so I don't want to say that, but Washington County has. There is no chief deputy in Washington County. They have, I think, 5 different division managers, which are essentially chief deputies. They are chief deputies, each of them, but they are their titles are actually division managers. And so it would be sort of a hybrid model. I'm not asking for or not recommending that there are 5, but an additional personnel that is in a supervisory capacity over a specific part of the office. Is that?
So then, what are you proposing then? You're gonna.
So to add that job function title,
job description,
and open that up to hire within the office one person to do that job, fulfill that role.
But more of a manager than a deputy? Is that what you're?
They'd have their responsibility to assess, but also over a specific part of the office.
Mm-hmm.
So you're basically saying you're going to put out a job description, open it to the office.
Correct. Yeah.
And for a chief deputy over residential and one over commercial. Correct.
Correct. Yeah.
And they'll have that job title, plus they'll continue with their assessor work.
Yeah.
Correct?
So we're going to divide some of the other roles and responsibilities which don't need to, you know.
And then you want approval to add a data collector part-time. Is that correct?
That's correct.
How many hours a week?
I'm thinking 20 right now.
20 hours.
Yeah.
Okay. And Dan, is that, I mean, budget-wise, where we at?
Dan, can you come up and talk in the microphone? I'm sorry.
And state your name.
Dan Jessen, Iron County Auditor. No, and this is just purely a budget opinion. We are tight in the assessing and collecting fund. We considered long and hard about the new DMV ad. It's been a tough year there, due to COVID and setting up appointments and all that stuff. The argument was made we've got to add somebody there. So Carson's department, along with Nicole's department, Carson is 100% the assessor's office funded from Fund 20, which is the assessing and collecting fund, which is funded by a property tax levy. We've just been getting tighter and tighter in that fund, and so that's just a reality, something to think about. If we get to a point where we have more expenses than revenues, there's one way to fix it. You either cut an expense to pay for new things like this, or you have to increase taxes. I'm not saying we have this today. I'm saying that fund is getting tighter and tighter. It's constrained.
So, if this was a part-time position, I was going to ask Karsten a question. So, if this was a part-time position, once you kind of get caught, you said you're quite a ways behind in your office. So once you kind of get caught up, could that position go away? Could this just be a temporary deal, and then you could reassign somebody that's in your office once you get caught up to do that job? Or that may help us make a decision on adding that.
So yeah, theoretically it could. But I think it goes back to the point that the attorney made, which is proactivity rather than reactionary.
Yeah.
I think as the county grows, which it is, the concept is to sort of not add significant burden to the taxpayer by adding a full-time assessor job.
Which, when you're paying benefits and all those things, is
by taking a small action now. So at some point, as the county grows, we're going to have to add an assessor. I mean, that's just just the nature of growth. But I think for the time being, this is a solution that would work.
So one more point, and then I'll sit down unless you have other questions for me from a budget standpoint. The new position that we created for the DMV, it doesn't have a sunset, but the concept, as we talked about it, is that when we're kind of beyond this extraordinary event, and there is some natural, what do you call it? What's the word, Jen? Attrition. When we do have some natural attrition, that we granted that position kind of from a budget perspective, that when there's some natural attrition, we would maybe reduce that back. So, anyways, which would alleviate. I mean, we do have fund balance in 20, and despite our budgeted higher expenses than our revenues, that doesn't always end of year come through that way. Like for this year, we were able to save a little bit of money with training and things like that. Also, we have the pictometry, which we have been doing the past few years. That's $65,000 a year, $65,000 a year. You know, you could possibly make some wiggle room there by not doing that every year. There's things that can happen, and I certainly don't want to seem like I'm not supporting Karsten. He's new. He's gonna want to make changes and grow things, and grow things. I say that, but I mean, he's gonna need to make an impact and find the best way to do efficiency. And you know, it's really hard when it comes to personnel and restructuring when you're set with a fixed budget. You know, he can certainly ask the commissioners to change the budget, and you can't just come in and just start moving people around in government like you can in business. So it's a challenge to figure this out, and he's trying to do that. So
I have a question for Dan. Yeah. So because of COVID and all that, having to get an appointment to go in and register your outfits, a lot of people have gone online. Yeah. Is that made an impact on that office?
We talked a lot about that. We looked, Jennifer actually had numbers with the traffic this year. The problem is we don't have the numbers to compare that last year. What we can look is we can look at the revenues that we receive from the state. All of the revenues that go from the Diem and go to the state, and then they reimburse us based on type of transaction. And we can see that those revenue numbers are falling. So I do believe that, and 2020 was actually a really low year. Our revenues are significantly down, but more people are doing it online. I personally believe that behaviors will shift. People will realize it's actually really easy to renew online. And so the demand for our services appears to be falling, and who knows what the effect of COVID will be on future behavior.
And them not sending out cards anymore, that is probably pushed them to that also, right?
Well, and I wish they would continue to do that, because that continues to, that's really the most efficient way to do it.
It is. I wish they would too.
Yeah, I wish I was kind of disappointed to see
I
them
was
stop
very
sending out those
disappointed.
cards, because some people will be like, "Oh, I guess I can't do it online anymore," and we'll go back into.
I know. I wish they wouldn't have done that too. It's a little hard for us older people to do that. So
that's something to factor in as well. It's kind of unique in that we have the DMV. I don't know. It's not unique, but it's an interesting paradigm. Whereas when you compare to the recorder's office or the auditor's office or the clerk's office, the treasurer's office here in the courthouse, we're doing our statutory function involved with the tax process, and poor Karsten, used to be Cindy, has this other thing that they have to deal with the DMV, and it affects the total size. And in fact, when we start looking at comparing ourselves to other counties of the different classes and different size of budget and different number of parcels and different all of these things, it skews the data. Well, you have to adjust for the fact of which of these assessors' offices have the DMV as a part of their functionality when you really do a apples to apples comparison to just find out where do we sit relative to them.
They do it differently in other counties.
Yeah.
Is that what you're saying?
Yeah, like in Washington County, it's a state agency. It is a state agency. We just do it for them because we have an agreement.
Yeah.
In a lot of counties, some of the more rural counties, it makes sense to have it be partnered with a county. Most of the larger counties, DMV is just a state agency, and they just it's hands off. And we've looked at that. Which would take a little bit of the burden off the county, but the level of service would go down if we turned it back over to the state. So there's a give and take.
They're eliminating us now anyway.
Yeah, I mean, if we turned it back over to them, I mean, that would be, who knows what it would do to the budget. We'd have to do an analysis, a budget impact. I suspect it would be a good impact, but you'd probably lose the service of the DMV in Parowan in the courthouse. And who knows what the level of service that they would provide. They may provide just as good of a level of service. I don't want to say they do it worse, but they're looking at it from a widget standpoint, and we're looking at it from a, hey, these are our friends and neighbors, and we want to provide the best possible service. So these are challenging decisions that you guys get to make. So hopefully I've spread, I've shared that thing.
So in light of this decision we need to make as far as adding a part-time, couple questions, Karsten. Number one, how far behind is your office? And number two, once by adding this part-time position, how long will it take you to get caught up? And once you do, through attrition, can we move kind of back to where we are now once we get caught up?
I mean, if I can answer that by just discussing my conversation with the elected official that is an assessor in Washington County. What he said is, in 2 years I've had to add just one additional employee with tremendous growth. So they've had a huge amount of growth, have had to add one single person. And the challenging thing to do, he said, was to sort of convince everyone that they needed to move away from a chief deputy and move to, 4 or 5 chief deputies to the model that they have now. And in terms of efficiency, he said, it's obvious, it's worked because we moved away from one thing. There was a cost to do that, but it has allowed us to operate in a manner where we haven't really had to add tremendous cost to the county outside of adding those changing those and reorganizing those jobs. So I mean, there are real challenges in that office. I think a lot of it is because of the way that the office is structured. I think that is all of the reasons that you're sort of discussing right now, all the challenges I'm having and probably will have for the short term are related to that. I think people can catch up if there's some change made, and that's essentially why I'm standing here. So,
okay. Well,
maybe it would be good to tell what that part-time person would do that would help. Again,
So they are.
So they measure and take a picture.
They basically, they have very limited job description. They go out and in an efficient way, rather than having tons of people going out to different areas, they just go out and they have a route and they
optimize a route.
And gather data.
Where now every one of the people
Where now
in
you
the
have
offices are going.
Yeah, and that still has to happen because, I mean, there's still, to some degree, that still has to happen.
Yeah.
An appraiser or an assessor still has to sometimes go out and visit a property and for, I mean, there's tons of different reasons, but the data collection is a way that, you can save a lot of time, money, I mean, in terms of just the time driving around, having the person that's really being paid the money with more office time to get more work done.
Well, and you can do it in a way that you can send them out and they can go to a certain area, right?
Yeah, or really a number of different areas all in a day rather than having a whole bunch of people.
Yeah.
I mean, that's
sense.
We don't have a team of data collectors here like they do in Washington County, but it's essentially what they've
done on their model.
On their model, and
Right.
it's worked for them. So my proposal is a little bit more of a hybrid because we're not 5 times bigger than we are, and
Yeah.
don't want to be. So yeah, that's my thought.
Okay. So I guess Commissioner Blake, do you have any comments on this item?
No, not really. I've been soaking it all in.
Okay. I checked with our clerk John Whitaker and we are if someone feels like we should make a motion to do this, we're okay to do that. Even though it doesn't say approval on the agenda, but if there was a motion that needs to be made, or if someone wants to make a motion.
I mean, I'm comfortable if you need more time to make this decision. I'm just saying, I think it's really probably a critical thing for this office to do to be efficient.
I mean, I've had some conversation with Karsten over the last week, and in light of what I've learned, I'm personally in favor of adding a part-time position. I do hope to do the data collection where they can go out and optimize and be more efficient in going around, and that's all they do is that, while the others can hammer out the reports and maybe try to get caught up that way. So I would personally be okay with adding that, hoping that when we get caught up by adding that position through attrition, we can.
Yeah.
I do know you mentioned by doing it this way, we could reduce the fleet. And so I think there can be some offsetting costs by reducing some of the cars that are required for that department, because you've got one person out doing most of the picture taking and measuring where we don't need near the cars. And so as we look at our new fleet system, I think by reducing, you told me you had 6 cars now, and we could probably go down to 3 or 4.
Yeah.
And so by reducing 2 cars, it seems like it could pay for that position easily, that part-time position.
I
and
think
so that's one reason I'm okay with this.
Well, as critical as the data collector is, I think is actually creating a position of division, a second chief deputy division manager that oversees really statistical residential land. It's all of it is under the one hat right now, and it is not an efficient way to get anything done. Not to get anything done, but to do it in a manner that really benefits a taxpayer, I think. And so that is even really more critical, I feel like, than the data collector. But both, I think, would actually serve the public and the taxpaying citizens. So,
have you had a chance to discuss or consider any budget ramifications of kind of having a dual chief deputy type system, or is
dollar per hour there's a change between potentially up to $3, a little bit more even per hour for whoever might. In some cases it might not be much of a change, but in some cases it could be
so
significant change. And
ballparking, it could be up upwards of a $3,000 a year.
I think when I was.
Is there a
3 or
certain
more.
amount that they go up? Could you split that where they're splitting the?
Not really.
Not really. Okay.
And I can speak to that if you'd like me to.
Okay.
That'd be good.
Yeah,
Would
our
be
chief
good.
deputies are a set salaried structure.
Jen, could you speak to the mic?
Yeah, of
Sorry.
course.
Yeah.
Yeah, I'll come over. Yeah, they are a set salary structure. So depending on who Karsten appoints, we'll open that up in-house if that's the direction you want to choose. It's anywhere from $1.50 per hour to $3.90 per hour ish for that chief deputy. And then as far as a part-time position goes, we would start them at a $14 per hour wage at 20 hours per week.
So that'd be
those are the
about
two.
$14,000 a year, and there's no benefits,
No
so
benefit
there'd just be the
with that.
14,000.
Yeah.
Okay.
There's a slight tax, but yeah.
Okay. Commissioner Blake, obviously you're the liaison with this department, and I mean I'm in favor of this. I don't know what you and Commissioner Wood think, but
No, I'm in favor. I think, and I know Karsten called me last week, right in the middle of my sickness, and
Oh.
I haven't had an opportunity to sit down with him and go over it yet. But I think it's been explained fairly well. I would probably be in favor.
okay.
Do I need to make the motion because it was part of the assessors, or?
Either one of you can. I'll entertain a motion from whoever wants to give one. We just need to include in the motion.
Do
We
that,
need
Mike?
to in the motion. We need to include restructuring, going from one chief deputy to two. Is that correct? Is that how we need to do that in the motion?
That's correct. Yeah.
Okay.
I mean,
Yeah,
Is that
that's
right?
yeah.
Okay.
Now, I think it is important to note, and we've had a couple of texts amongst the elected officials to just point out that chief deputy position in other offices is not a career service. It's an at-will position, and in most offices now, Carson's office requires greater certifications. So there are cases where the chief deputy would not make as much as perhaps someone with another certification. But in many of our offices, the chief deputy is significantly higher than the others. It's an at-will position, and it's becomes a political position as well. So I'm not sure what the ramifications of having a dual chief deputy are. I'm not opposed to it. I think it's worth noting that that's the paradigm amongst other offices.
Did you say that was done in Washington County? Is
yeah,
it too?
basically.
I don't think it's without precedent.
Okay.
Yeah.
Say that they were a management position.
He calls them division managers and not chief deputies, but they, I think, are at will.
See, and I wonder
Wow.
in those positions. I don't know. I mean, at will is certainly a hazard that's kind of built into these chief deputy positions typically, and I don't know whether we would. I mean, they.
Yeah,
personally, I
mean,
would rather
I think maybe
have the
we-
career service protections if possible.
And maybe we could
If it were me,
adjust that. I'm not sure. Okay.
yeah. I mean, it's baked in, right? Yeah.
And in addition to that, we would not be hiring another position to fill.
Yeah.
Jennifer, why don't you come up to the mic and
Oh,
just you
sorry,
can both
yes.
stand. You can both stand there, Carson,
Just-
just
yeah, stay.
so we can get on the
So
record.
we would not be hiring an additional person to fill for that vacant position. They would just be
Right.
In-house.
over in-house. And it's just kind of like our attorney's positions. We do have 2 chief deputies in our attorney's office.
So it's
one
not without
covers full,
precedent.
One covers, yeah.
And are they in that case? Are they both at will?
Yeah.
Okay.
But they
And they both.
all step down into a deputy 4 or 5, whatever.
And I guess they would know whether they wanted to apply for that, going into it
Going
with their
into
eyes wide open, knowing that that's an at-will position.
And that's what we would put in the in-house posting.
Okay.
They would, be advised of that.
All right. Well, I'll entertain a motion if somebody wants to.
Do you want to, Mike, or do you want me to?
Sure. Okay, I would move for approval of, first of all, to approve a new, an additional chief deputy position within the assessor's office that would most likely be a promotion from within. pay grade, pay raise that would go along with that. And I would also move for approval of a part-time, and remind me what the title of the part-time is.
Data collector. Yep.
Yes, I would move for approval of a part-time data collector as well.
I think you want to specify, because the pay grade that goes with that is the way Mike put it. And there's a varying pay grade depending on.
Oh,
They
their
were
certifications.
Maybe, I think $14 an hour was what Jennifer was alluding to. Okay. So you want to
Yeah,
include
so
that, Mike?
with the pay grade being starting pay grade of $14 an hour on the data collector.
I'll second that.
Okay, it's been moved and seconded to basically add another chief deputy from within. Those will be advertised as an at-will positions, and also adding a data collector part-time at $14 an hour, so there would be no benefits included.
20 hours a week.
Chief deputies. This is why I get hung up on chief deputy, because there's what it is different than a normal thing. They're appointed, so Carson wouldn't hire from within.
He
would
can
just
appoint them.
somebody.
Oh, right.
He would just
That's what I was
get a
going to-
sword and
to
he would
point
anoint
out.
them, and they
Yeah.
would now become chief deputy.
Yeah.
And would they become chief deputy like his other chief deputy in terms of pay, or would they become chief deputy like the other chief deputies in the offices here? That's what I'm saying. These are details that they're important to specify, because they have
I will
lots
say,
of different.
amongst the chief deputies, not all chief deputies are
But
paid
they're
the same.
appointed.
In most cases they are, but in cases where there are certifications, or like the attorney's office or the sheriff's office, there is a difference in pay.
So,
Significant
in
the current chief deputy there.
Well, because he's an ad valorem, whatever that.
Ad valorem.
So in light of that new information, so do we need to amend that motion?
Would you say to have Carson appointed rather than hire
So,
from within?
okay. You want to amend that, Mike?
Yeah, what was that?
So basically, Dan was just saying that because they're chief deputies, those can be appointed. So Carson, rather than put it out to the whole office, Carson can appoint those positions.
Okay.
So.
All right. Yeah, so in reference to the chief deputy position, that can be appointed by Karsten as the assessor.
Okay, so we'll need
Second.
So it's been moved and seconded with that revised motion. All in favor?
Aye.
Aye. Motion carries.
Thank you.
Thank you, Karsten.
You, Karsten.
We will go to D, policy revisions.
Right, let me give you those so you have them.
Thank you so much.
All right, we'll start with section 2. We're just kind of doing some cleanup here and there. And in section 2, specifically A.
That's fine, yeah.
Sorry, Jennifer.
Sorry. No worries. A in compensation. Originally, we have been on a step and grade pay structure, and about 5-ish years ago, they changed to just a grade, a pay range scale. So I wanted to change the wording in that so it was kind of more fitting into what we have currently. So in the red there is all of the things that I've cut and added. So I can add, I'm going to read that section just so I can have it open, and I also send this out so everybody sees it as well. So Iron County has a compensation structure in place by which all positions are assigned a pay range. Each established pay range has been predetermined but is subject to change upon approval of the Iron County Commissioners. The pay of a particular position is determined by the Commission upon recommendation of the HR Director and respective department heads. And then further down, I just changed grade to pay in a couple of sections just to stay consistent. I took out that elected officials are exempt from the compensation structure because we're not doing the step and grade any longer. So that's section A. Same with down at the little change grade to pay on those as well. So on the next page, in the last, it looks like in 2013 this was changed, and a couple of sentences were inadvertently taken out that need to stay in because we do pay for an emergency overtime pay. So I wanted to kind of put that on record that we're putting it back in. And specifically, there are two different departments and then one specific job that covers. So I want to be putting that on record that the roads department, as well as the landfill and Curtis DeMille, on the rare occasion if there is a flood, will affect on this. So emergency overtime shall be earned at 1 1/2 time the regular rate of pay for general non-exempt employees. Emergency overtime pay is intended for commission-approved job positions and is subject to leave time reduction. So that's section 2 changes for your consideration. And I don't know if you want to vote on all of them at the same time or.
So at the top of that, so Alma's was the commission chair before, and you've got Mike Blake.
Yeah, and I can change that for today if that's something I need to do.
I was going to take over.
Yeah.
On Alma's.
Yeah, this is just for the commission chair for that year. So he's the.
The chair.
The
Okay.
chair.
Okay.
But I don't know if you want me to change
These
that
other
for today.
documents I've signed, I've just signed them as Paul Cousins pro tem.
Correct.
So
Okay.
that it shows on the
Still
record
shows
that I
on
was
record.
Very good.
Mike's the new chairman, but
Yes.
I just signed him as pro tem. So I can do that today, I
Okay.
think.
You bet.
if
And
you
I don't
need.
have anything for you to sign. As long as you have it on record that you're approving those changes, it should be enough.
Okay.
Okay.
Let's just do the other ones. I think we can do them
Yeah,
all.
we can do section 7. So on the employee status on section 7, this was drafted before we had policy 43, which covers volunteer status in detail. So I just thought it was a little redundant to have that big of a section for volunteers when we're already covering it. So I did take out most of that verbiage in there, and then just put in there that Iron County shall abide by all policies and procedures in accordance to the Fair Labor Standards Act, and volunteers shall adhere to section 43 of Iron County Personnel Policies and Procedure Manuals. And so that's the only thing that I put in that little section because we will cover it in section 43. And that's the only change on that one.
Okay.
And then on compensation section 2, just kind of backtracking a little bit, inadvertently we're going to have to change section 3 because it does talk about step-in pay, and I'll probably bring that to your attention next commission meeting just so we kind of stay consistent on that. So now we'll go back to 43. 43, I just changed a little bit of the wording in there just because, and it's probably personal preference, just me as opposed to who wrote it before. So I took out process and put in procedure in that top section.
Hey, Jen, I'm so sorry. Mike Edwards is hoping to speak up, and he's being very polite, but
of course, I'd love
think
to hear his input.
he
Absolutely.
he didn't want to cut you off, but he was also not sure he was going to be able to be heard.
Okay, yeah, I would love for his input.
Yes, we can, Mike.
Okay, my comment was on this 43, so I'll just wait till Jen's done.
Oh, I'm so sorry. Okay, thanks.
Okay, so on the very first top, section A, it's just I took out process and replaced it with procedure. This policy outlines expectations for all Iron County volunteers. Section B, I just put work and changed it to a job description because we do job descriptions within Iron County. And then on the next page, if you turn that over, I took out that very first sentence and then replaced it to volunteers may be reimbursed per diem for travel expenses as well as other actual expenses in performance of their volunteer assignments. Said expenses and any other paid stipends must have prior approval from elected official and department head. So that verbiage has changed a little bit. And then number 10 is just changed to add in that we are in accordance to the American with Disabilities Act of 1990. I think that's important to have in any documentation when you're speaking of volunteers. So I would love to hear
what Mike
Mr.
has
Edwards
to say.
Yeah.
My concern was over section 6, and I should have come to Jen after I thought about this more because she and I spoke earlier, and,
Yes.
and she went over this stuff with me, and I didn't point this out at the time because it didn't come to me, but I'm suggesting that we maybe think about section 6 a little bit more. My understanding is that this is directly in relation to volunteer firefighters. Is that right?
Correct.
I'm wondering if we just want to be that specific about it and just say that, because I think there's a number of volunteers in the county that I don't believe the county commission has any intent on paying or
such as the
Might
fair
be
or
understood.
something like that.
Correct.
So it might be
And
a real
it's
big slippery
just
slope.
that if the elected official or department head over that office or department decides that, it looks like they could be paid, and I don't think that's what you're intending to do. And so I wonder if we just go with the generic statement that you had before, that volunteers don't receive compensation by the county for their services, and then say, however, there's an exception in regards to the volunteer fire departments, as will be approved in an annual budget or something like that.
Sure.
And I don't want your exception to overtake the rule that you're not going to pay volunteers.
And that's fair, and I would love to get with you and get the best wording possible. Absolutely, I am great with that. And there is a proposed, I guess an approved thing when I can't even think of the word now. President Trump last year signed into law specific paid stipends for only firefighters, and I have that on my desk and I can go grab it if we need to. But if we want to bring that to the table next commission meeting, I can cover that in detail if
That
you'd
might
like.
be better on that one.
So
I'd be happy to do that.
Mike Edwards, should we vote on the first two then and hold off on this one, or how should we handle this?
I think you can do that, or we can just approve the language as Jen's proposed it, or we can change it just a little bit right here, or we can
Let's
bring
just do that
whatever you
then.
want.
Okay, so in the motion we could add those changes and just vote on them now. I'd rather do that if we're good with
No,
that.
that's
Yeah, that's fine with me.
Okay. You good with that, Mike? Blake?
Yes.
Okay.
So should I make a motion for policy revisions? Number 1, section 2, compensation, introducing emergency pay that was inadvertently omitted from the last revision, and number 2, section 7, employee status, minimizing volunteer phrasing because section 43 covers volunteer status in detail. And then on number 3, section 43, volunteers in general update to policy. And we probably need to take away that we pay of any of the pay strata and put in that extra pay can only go for firefighters.
So can I jump in for just a second? So it sounds like your motion is to approve the first two policies that were for your consideration, right?
Right. To
And then on
approve them,
43,
yes.
you're just suggesting that on section 43B6, that the first sentence continue to read, volunteers shall not receive compensation by the county for their services. And then maybe on the second sentence, put the word fire department before it says volunteers. So it says fire department volunteers may be reimbursed for their per diem and travel expenses, as well as other actual expenses in the performance of their voluntary duties. And then we can just strike the next part and just say that this will be only as approved during the annual budget of the county commission.
Now, there are
like that.
some of the sheriff's office that do get paid for travel expenses if they're in training, so I don't know if that matters.
Okay. So then maybe you just put, maybe there, instead of just saying the fire department, say said expenses and reimbursements must be approved by the county commission during the annual budget. And that way it covers
that's
everything
fair.
that you guys have approved and nothing that you haven't.
Yes, I love that. Okay.
As Michael has
As he
stated.
All right. Discussion on the motion. Bill, you had a question?
The police department, when they go to their training, they're not volunteers, are they?
The VIPS people are.
Volunteer and police service, is that what we call them?
And
Okay.
search and rescue.
Okay, so we got a motion on the table, and Marilyn said ditto to what Mike said, right?
Right.
I will second that.
Okay, so it's been moved and seconded as described. All in favor?
Aye.
Aye.
Aye. Motion carries. Thanks, Jennifer, for your
Thank
work.
you.
Thank
I
you.
appreciate it. And thank you, Mike, for jumping
Thank
in.
you,
That
Mike.
helps me a ton.
Sorry, I didn't mean to interrupt.
No, I appreciate you doing so.
Okay, I failed to, because the format was a little different in the last meeting. I failed to give time for commission reports. So, Commissioner Blake, do you have anything you'd like to report?
No, not this go around.
Okay, Commissioner Wood, do you have any report?
I just wanted to report that I talked to Jan Worthen about Mike and her. They were both in the hospital with COVID, and I reached out to her, and she said that they're doing better. Mike's trying to get back to work, doing most of his work at home, but he went in the office, I think, on Friday, and worked an hour and a half, which they were very sick, and but they are recovering, and she figures that they'll be back going, not too long. So, you know, I was really glad about that. We were really concerned about them. Other than that, I think that's one of my main ones that I wanted to say.
Okay, I have a couple things. The senior center addition is coming along beautifully. They're sheetrocking, taping, and so they'll be painting probably end of the week this week, and they'll start flooring and base and finishes with plumbing. And is that what you see, Terry? And so that's awesome. It's looking really, Carter's and their subs are doing a beautiful job, and don't you think, Terry? I think it's turning out really nice.
I got to go in the other day too, and I was really impressed. It's going to be a beautiful facility.
There are some good contractors, and they all have done an excellent job.
So that's exciting. Hopefully, we can get COVID behind us, and seniors can use it. So, because Mike or Commissioner Blake was down this week, Lieutenant Riches from the Highway Patrol called, and I did meet with him. I let Commissioner Blake know about this. He reported to me that, and Dan, you might want to make a note of this. I don't know, maybe you already have it, but they spent $61,738.50 of the $100,000 we budgeted them last year with their safety stops, is what I believe they called them. So met with him. We met over at the public safety building. There's been some concern where the dispatch is. There's some sound. Terry Palmer and Lester Ross and I met over there, talked about some sound issues. We canceled an order on some surround on the generator, its backup generator itself, and decided we'd look at bids for a laminated glass and possibly a masonry wall to be erected to what would be considerably less cost, and we think that that's going to solve the issues they have with the sound. They have to run that generator. What is it? An hour and a half every week or something.
Under state law, for the backup for that, they've got to run it for an hour and a half once a week.
Right.
We do have all three glass companies in town that are writing up bids on the windows right now, and we're trying to contact a mason company for a bid on that.
Perfect. Okay. So we're working on that issue. So those are the things I had written down. Other than that, I guess we've got the non-delegated items, prey dog matters. Is there anything dealing with prey dogs or the county boards? I know county boards, we've got some work on those. So when Commissioner Blake gets back to full strength, we'll sit down and kind of discuss assignments and boards. And I know there's some, I've got a couple that I'd like to talk about. I know Commissioner Wood has one. But if that sounds good to everybody, and Commissioner Blake, I hope you start feeling better.
Me too. This sucks.
No kidding.
Well, take care and get better soon. So. All right.
Thank you.
Thank you. So with that, Chair will declare this meeting adjourned. Thank you very much. Chair Pro Tem, that is.
Thanks, guys. Sorry, this was kind of a mess.